Morning, everyone. We're ready to begin. So, Geoffrey, I think there are four matters of law that we're going to deal with this morning. Hopefully, hopefully most of them will be quite short, I think. Firstly, the Section 67.
Yes.
Secondly, there is, at least in inverted commas, standard of proof upon which you've given submissions in relation to paragraph 1. Third, there's the application for permission to question 3 witnesses. And fourth, there is the application for redactions in relation to the radar barges. Can we just deal with those in turn, Sir Geoffrey? In terms of Section 67, firstly, thank you for your written submissions, which were helpful. I think it's right to say that the issue turns upon a narrow and quite a simple point. I mean, a simple point at least to put, even if not to answer. And that is in Section 67(7) of the Constitution, whether the words as they're described pertain to such contract or pertain to becoming a party to such contract. And you say it's the former.
Yes.
Can I just raise two questions in relation to that before we ask Mr. Rowett if he has anything to add? Firstly, as I understand your construction, which I think I do understand, if an individual member enters into a contract with the BVI government, then unless he obtains an exemption under Section 67(7) before the event, he then has to vacate his seat on your construction. Yes. But if the member in any corporate, I'm sorry, just pausing there for a moment, and that I assume includes a DBA, which is really the individual simply trading as a particular name. But if the member trades in corporate form or as a partner in a firm or as a director or manager of a company, then he doesn't have to vacate his seat if that firm or company enters into a contract with the BVI government, if as soon as practicable, after becoming otherwise interested in that contract, he discloses to the House and that interest and thereafter obtains an exemption. So there's a difference between an individual acting as the party to the contract and an individual not being a party, but merely being a partner in a firm or a director or manager of a company. Is that correct?
Yes.
And can you help me with this? And what is the purpose behind that distinction? Which means that if a member enters into, I would have thought even a works order, but certainly a petty contract with the BVI government in his or her own name for anything, for sandwiches, and doesn't obtain the exemption, then he or she is out, has to vacate the seat. But if that member, literally in corporate form, enters into a contract, he or she is not necessarily out. What's the, and that of course could be a very large contract. So what's the reasoning behind that? What's the possible reasoning behind that?
Well, exactly. I think the important point is the words in Section 67, which of the Constitution, 67(7), which is before becoming a party, you do not become a party to a contract if you are a partner in a firm that contracts or a director in a company that contracts. So plainly in our submission and the attorney's submission, the draftsman of this section of the Constitution considered that there was an important distinction between somebody who became a party in their own right, that is to say they had to contract in their name as themselves, and somebody who became interested in a contract via some other legal entity or vehicle, corporate partnership, and so on. Now, the only practical thought that I can submit to you is that in some cases that would make perfect sense. Because if you were a manager or a director in a business that was incorporated, where managers were entrusted beneath you to contract, it may be more likely in that sort of structure that you would not find out about it at the time. But whether or not that is a sufficient practical basis for the distinction that the draftsman draws it, we submit, is compellingly clear. You simply cannot say, and our argument continues as you will have seen, you simply cannot apply the meaning that was put to me some weeks ago, if I may respectfully submit, that otherwise interested must mean interested in a manner that isn't described in section 67.3e, because of course that would not be disqualifiable. You're only to be disqualified if you are become interested in the contract either by contracting in your own right when you're a party, or if you become interested because you are in, and it's a closed-ended description, a partner, a director, or a manager. So we submit that it's quite plain that the draftsman is drawing this essential distinction between somebody who contracts in their own right, in their own name, and somebody who doesn't. And we submit it's a compelling fact, a compelling construction. It's the long-standing one that's been applied. It doesn't make sense to apply the construction that in my respectful submission and in the attorneys, that somehow or other the other words otherwise interested must indicate some other form of interest other than that contained in section 67.3e.
No, Sir Geoffrey, I understand that your submission is that the words on their face are plain. I understand that.
Yes.
I just wondered, and you've answered the point as well as you can.
As well as we can.
Because we have to look at the words.
We do.
Looking at it in a purposive way, what that dichotomy might be based on. The second point is this, and I assume that this has been done, but on the basis of the construction that the attorney favours, which you say is clear, as I say, a member who has become a party to a contract in his or her own name or as a DBA has to vacate his or her seat. And I assume that a check has been made of the current members as to whether any fall into that category.
I would have to take instructions on the latter point as to whether there is a check being made, but I'm not aware that it's thought that there are any into that category.
Okay.
I mean, I've obviously held discussions with the attorney. We haven't addressed this point precisely, but clearly we've been inquiring into the history so that we can assist you with what's happened in the past. And I'm afraid you've got the results of those researches.
No, Sir Geoffrey, I understand that, and I know you. I know, and I see the force in the submission, your submission, that the words are clear. That's something I'm going to have to think about. But I think probably this point has not been focused upon necessarily in the past, and that's why I raised that question.
And
now.
I quite understand why you do. I mean, one thing one should add is that we've endeavored to look at comparative jurisdictions. There's a similar wording in the Cayman Islands, but we've been unable to find any authority on the point. Otherwise, I would have put it before you.
No, thank you very much, Sir Jeff. Just see if Mr. Rowett has anything to add on section 67.
Firstly, that I would agree with Sir Geoffrey that there isn't any useful law out there. My searches didn't reveal anything. In terms of the operation, and Commissioner, I don't know whether you have the Constitution and Law bundle to hand, yes. But the provisions are at pages 36 and 37 of that bundle. Perhaps it's helpful just to start by reminding ourselves how we got here.
Yes.
And so our starting point was section 66 F, which deals with those who seek election to the House of Assembly. But that section obviously prompts two important points. The first is that if it is complied with, it gives the electorate full detail of the extent of any contracts that a candidate may have with the government of the Virgin Islands. And secondly, that we see that the wording, the reference to a party to, or a partner in a firm, or a director or manager of a company which is a party to, is replicated in 67.3e and 67.7. When we turn to section 67, we are of course dealing with the position of someone who is already elected to the House of Assembly. As you observed on the last occasion, 67.3e is draconian. If you fall within its scope and the person does, and the House of Assembly won't grant an exemption, then you are out straight away. But in my submission, I would contend for the alternative construction, which I put forward in oral submissions on the last occasion. At that time, it was a provisional view, but what I would say is this, that if one looks at 67.7, it has two limbs. The first, which operate independent of each other. The first would be, if in the circumstances it appears just to the House of Assembly to do so, the House may exempt any elected member from vacating his or her seat under subsection 3e, if such a member, before becoming a party to such contract as there described, discloses to the House the nature of such contract and his or her interest, or the interest of any such firm or company in it. The second limb would then be, if in the circumstances it appears just to the House Assembly to do so, the House may exempt any elected member from vacating his or her seat under subsection 3e, if such member, before or as soon as practicable after becoming otherwise interested in such contract, whether as a partner in a firm or director or manager of a company, discloses to the House the nature of such contract in his or her interest or the interest of any such firm or company in it. I make that submission for the following reasons. Firstly, that the words as they're described should not be read narrowly. What you should look to is the phrase, sorry, if I could have a moment. Party, such contract as there describes. That is a direct link back to section 67.3e and to all the circumstances set out there. And that provision 3e covers not only where an elected member becomes a party to a contract in his or her own name, but where a firm in which he or she is a partner or a company in which he or she is a director or manager enters into a contract. So it's not limited to a direct interest that the individual has in a contract with government. Second, if one wanted just to capture the circumstances in 3e, in section 67.7, because as Sir Geoffrey points out, the purpose of 67.7 must be to afford an opportunity to be exempted from having to vacate your seat. It is difficult to know what the words "after becoming otherwise interested in such contract" add, because they taking them away won't actually undermine the force of 67(7). The third is that I question why the need then for "before appearing twice." I say that because if I take you, Commissioner, back to the submissions that were originally made on behalf of the attorney on 13th September 2021, one of the questions that was asked, and this is at page 5, was, as a matter of law, what is the purpose or intention behind section 67(7) and the operation of section 67(7)? And on behalf of the attorney, Withers submitted this. This section provides a mechanism for an exception in appropriate cases, i.e. where it appears just, to the rule which would require a member of the House of Assembly to vacate his or her seat upon becoming party to or interested in a contract with the government of the Virgin Islands, provided that the relevant member has disclosed his interest as soon as practicable. So the attorney at that point was not making the distinction which I understand Sir Geoffrey now makes, which is that if you have a direct, if you are the direct contractor, the effect is that if you haven't declared the contract or declared the interest before entering into the contract, you will have to vacate. Whereas if you become associated with the contract in a different way, you would have as either before or as soon as practicable. So you'd have a further opportunity to declare your interest. The fourth point I would make is that when one looks at what I've called the second limb, it does link the reader back to section 67(3)(e), because it makes reference to such contract, and that reference can only be directing the reader back to section 67(3)(e). The final point I would make, and it's the point that you've made, Commissioner, is that it is difficult to understand the rationale or to even come up with one which would justify the approach that the attorney is now putting forward, because the sole trader, if you like, who might be a relatively small entrepreneur, would be caught by the analysis or by the submission that Sir Geoffrey makes on behalf of the attorney, and would, if they only make a declaration after the event, they would not be able to rely on 67(7). Whereas someone who is involved with a large multinational company that has a number of contracts with government, and that person knew that their company had contracts with government before becoming a member, would be able to rely on as soon as practicable. And we've seen, and you've heard the submissions that are made on behalf of Honourable Neville Smith in that as soon as practicable has a subjective element to it, that the effect is that you would only need to take steps to seek an exemption once you became aware of the contract, which could mean that you become aware some considerable time into your tenure as a member of the House of Assembly. So for those reasons, I would argue for the alternative construction, as I've called it, to section 67(7).
Thank you. Geoffrey, firstly, I reiterate that I see the force in the submissions you make in respect to the construction. 2 points do concern me, which make it less clear than it might otherwise be, on neither of which I suspect you can give any further help. One is the point we've already discussed, and Mr. Rawat referred to it, and that is the question why. Why is this differentiation? And none of us can go too far on that, because we just have to construe the words that are there. And the second thing is, and this is a point of construction, that the word that we're looking at, or before, as soon as practicable after becoming otherwise interested in such contract, brackets, whether as a partner in a firm or director or manager of a company, reflect 67(3)(e), but they do not replicate them. And of course, as a tentative construction, where different words are used in the same statute, it is a tentative construction that they usually mean different things, but that may simply be a conundrum in relation to this particular subsection. I think an overarching point, of course, is that it's not my brief to construe the whole of the BVI Constitution, and it may not be necessary for me to resolve this issue if I conclude that there is an issue to be resolved. And so I think that we can, unless you've got anything else to say, Jeff.
No, I mean, you don't want to hear me in answer to that. I mean, the fundamental problem with Mr. Rawat's interpretation, of course, is that he simply offers no serious or credible answer to why the phrase is becoming before becoming a party as they're described simply means becoming a party as they're described. The only way section 67(3)(e) provides that somebody becomes a party is by contracting in his own name. I mean, really, I don't want to be impolite, but the truth is the words here are pretty clear, but they do, of course, give rise to the interesting conundrums that you've expressed, and I can see why one might look for another meaning, but the literal and ordinary meaning of this is the one that's been adopted. And I think I quite understand the point about the odd use of the expression otherwise interested. One rather suspects the draftsman simply adopted it as a shorthand, and the compelling nature of the other factors that I've drawn to your attention, I would submit, clearly demonstrate that this should be construed in the manner the attorney submits is correct. But may I move on from there, because I know we've got much more to deal with today, and it may be better if that one is, I agree entirely with your analysis. It'll be a matter for you to decide whether you really need to come to a view on this. There's plenty else for you to come to a view on. This may not be one of the things you need to.
Yes, no, Sir Geoffrey, I agree. Can we move that on then to what's referred to as standard of proof, at least in inverted commas?
Yes.
And this is the construction of paragraph 1 of the terms of reference. And I've had and we've discussed the meaning of corruption, abuse of office, or other serious dishonesty in relation to officials. We've dealt with that. This is another aspect of the same paragraph, and that is really the proper approach to the establishment of whether there is information that corruption, etc., may have taken place in recent years. And again, thank you for your short and focused submissions on this. Can I just raise one or two questions just to clarify? The word information is used in paragraph 1, and what you say that in this context the term information means evidence of facts. I mean, and it seems to me that that's right, in the sense that it at least includes evidence. It may possibly be wider, but it certainly focuses on evidence. And if we say that information equals evidence, that seems to me to be fine. And that's your first proposition at paragraph 8.1. Yes,
the first proposition is, what meaning do you give to information? That's what we've had to grapple with, and no doubt with which you are grappling. I suspect in a good deal more advanced way, because it would have no doubt troubled you from the outset how you would look at this question of information and what it means. Essentially, what we submit, but we fully accept that in an inquiry of the nature you're conducting, this is a matter for you. And furthermore, it's got to be flexible. There's not a question here of tying you to precise forensic probative standards. But given the emphasis on there is information, what we would submit, I think, is that there has to be facts. It's not enough just to say, well, I've had a piece of information in a bottle that's arrived anonymously in a bottle in the sea. This information has to be robust. It has to be live up to appropriate standards, upon which you could make and reasonably draw conclusions. Now, we've offered a thesis here that it is effectively tantamount to saying, are there facts? Are you in the presence of facts which you can comfortably find on varying scales of probative standard, before you then ask yourself the main question is, from which you can deduce that certain conduct may have happened. So what I'm anxious to clarify for you is that we don't say it's enough just to say, well, I've got some evidence here. You've got to be satisfied. We would submit it would be appropriate for you to be satisfied on some objective scale, which we've indicated in writing, that those facts genuinely exist. Thus, there is information.
Yes, we really have to separate out, because they're conceptually very different, evidence from facts. Information is the word that's used, and what you say is that information means evidence. Evidence, of course, is all facts. You can't have any other sort of evidence, but information means evidence. So I understandably, I can only act on evidence. And there has to be evidence. There has to be evidence.
Exactly.
But once I have evidence, then we move on to the second part of the phrase, whether corruption, etc., may have taken place in recent years. And you say in, I think, paragraph 9, that there has to be, at least you say, a real possibility that paragraph 1 conduct has taken place on the basis of the evidence. And I mean, lots of other phrases could have been used, but real possibility seems to me to be fine. So that on the evidence, there has to be a real possibility that corruption, etc., has taken place. But that's it, isn't it?
Well, we've tried to go a little further than that, as you probably detect. What we say, I think, is that evidence must have some standard applied to it. In other words, you'd have to find it. You'd have to find that the evidence was to your satisfaction and did establish the fact on which you concluded that it may have happened or may not.
But the evidence has to establish whether corruption, etc., may have taken place. That's what the evidence has to do.
Yes, but there may be facts from which you would infer that. The question is, to what standard do those facts from which you might draw an inference that certain conduct may have taken place have to be established?
But this is not an inquiry, as many other inquiries are, which seek to establish facts in that sense. You've referred to some of the inquiries. This inquiry, paragraph 1 seems to me to be very clear. This inquiry has to establish whether there is evidence, information, evidence that corruption, etc., may have taken place in recent years. And to make that conceptually simple task, it's not simple in practice, but conceptually simple task, more difficult concepts from other inquiries with very different terms of reference as to whether what happened, which these inquiries are investigating normally, did take place, doesn't seem to me to be very helpful. As I say,
well, it's not an intention to be helpful. I think what we felt, and what is that clearly a finding that there is evidence that something may have taken place does require you to be satisfied in some way that the evidence is capable of belief, reliable. You simply couldn't. I mean, if you didn't believe the evidence, for example, or you felt that the evidence was inconsistent with other evidence and therefore raised real questions as to whether you should rely on it, what then? I mean, is it really the case that you've come here for 9 months, as it now turns out to be, and all you're being asked is there some evidence upon which something might have happened? Surely we must have a more, if that's all you're being asked to do with respect, I'm not sure how far it takes us. Evidence that something might have happened. I mean, of course, that there may be some evidence that something might have happened, but where does it take us?
But Sir Geoffrey, that leads us to other questions. It doesn't affect the proper construction of paragraph 1. That goes off then into other questions such as recommendations.
Yes,
I fully accept that. Let's just take for the moment that paragraph 1 means what it says, and my task is to establish whether there is information, that is evidence, that corruption, etc., may have taken place in recent years. And I determine in respect of something that has been established. But recommendations then that flow from that may be dependent upon likelihood. I mean, if
right.
You said real possibility, I've no great argument with that as a phrase to with regard to the word may. But if there is merely a real possibility that it happened, then the recommendations may be different.
Yes, I agree.
Highly likely to have happened. So
yes, I agree.
I'm not saying that those questions are irrelevant to the terms of reference, because they may be highly relevant to other aspects of it, but simply in respect of paragraph 1, I find the leisure demand between paragraphs 8.1 and 8.2 of your submissions difficult, because 8.1 says the term information means evidence. 8.2 starts if finding such facts exist, and there's a I don't say this unkindly, but there seems to me it to be an incongruity between evidence and facts. But as I say, I fully accept that gradating the possibility, the chance, as you've suggested in 8.2, 8.3, and 8.4, in the context of these terms of reference, may be necessary, may certainly be helpful in determining the recommendations. But
I think with respect, that's what was on our mind.
Yes. Well, no.
Is that how you then move to making recommendations will depend upon a flexible scale, which will depend on the nature of the recommendation in your mind, its substance, its weight, its reach, and so on. And so we felt perhaps we should have done it in stages. And looking back on it, I think you're, if I may say so with respect, right. It is pertinent to the question of what you then go on to recommend. Our concern was simply that if you were simply basing it upon so slender a footing as whether or not there might be information that something might have happened, because I mean, it's not what you're postulating. It seems to me, and I may be wrong, and you will tell me, obviously, sir, if I am. But essentially, what you're postulating is something akin to that which might afford reasonable grounds to suspect to a police officer. What effectively you're saying is that paragraph 1 or simply invites you to say, do I have because I don't think one can say that information, and I don't think you're saying, as I understand it, that information means something that doesn't have standards which can reasonably be capable of belief. The police officer who is arresting must believe, and the facts stated to him must be capable of being believed before he has reasonable grounds. But if that's what you're saying to me at that point, do I have information, evidence that is capable of being believed, and which by, I think, definition, sir, you this may be an open question, but which you believe yourself to be likely to be true, then thereafter you move forward to seeing on a higher scale or a flexible scale as to where that leads you in terms of recommendations. I don't think we differ from that. I think the concern we've got is, as I say, when you reach the second and third stages and ask yourself what should be done, because Jeffrey, that of course is far-reaching.
Yes, no, absolutely, but that's a sort of distinct exercise in a sense. Once I've made relevant findings in relation to paragraph 1, I'll need to go on to consider things like recommendations. But also, you can't look at any particular finding under paragraph 1 in isolation. I mean, just for example, and this isn't this is entirely hypothetical. This doesn't relate to anything in relation to this inquiry, but the recommendations are going to be very different if there is one instance of a mere possibility that may not be any more than mere possibility than if there were findings in respect of lots of incidents which may be greater than a mere possibility. So it's a matter of taking the whole thing into account at that stage on recommendations. But none of that, in my view at the moment, bears upon the construction of paragraph 1, where the hurdle is the hurdle is a modest one. Having said that, I also take into account this, that one would not leap over even that modest hurdle, I don't think, in respect of public officials, particularly senior public officials, without some very considerable thought and some anxious scrutiny. But
I think, if I may say so, yes, that again was in our minds, that the threshold for the kinds of behavior that you're being asked to look at on paragraph 1 do admit of, again, a sliding scale of anxious scrutiny, and possibly even the approach that Lord Hoffman took, the famous approach of whether it's a lion or an Alsatian in Hyde Park. But
Mr. Jeffrey, I agree with all of that.
Yes.
And as I say, if by way of a hypothetical example, there was only one instance where I'd be minded to make a finding under paragraph 1, then for the reasons Lord Hoffman set out, I might not be minded to make those findings because it may be inherently unlikely. I mean, that's broadly the principle that we wanted to draw to your attention. That's Lord Hoffman's view. As I say, none of the all of the examples I've used are hypothetical, because I've got to hear the remainder of the evidence and think long and hard about everything I have heard. But that's very helpful. Just before I ask Mr. Rowett if he's got anything to add, is there anything you want to add at the moment, Sir Geoffrey?
No, thank you, sir.
Mr. Rowett, anything to add?
Very briefly, Commissioner, I think the position we've reached is that Sir Geoffrey is not pursuing the apparent sort of two-stage approach that was set out in his written submissions, which was that first you make findings of fact to the civil standard, and then you may go on to consider whether there has been behaviour that comes within paragraph 1 to a lower standard. And I think in my submission that is, he's right not to pursue that approach. What we have to remind ourselves is that you are conducting an inquiry bound by your terms of reference. What you are asked to do is not to determine civil or criminal liability, not to adjudicate between competing cases, but rather to answer the question in the terms of reference, and to do so by where necessary, and only where necessary, making findings of fact. You are also entitled to make statements of opinion and to make comments. So I think we shouldn't conflate evidence with the standard of proof. The evidence is what it is. It is a bulk of information that you will have to hand. You are in a different situation from the English inquiries. And I know Sir Geoffrey in his submissions refers to Al Sweeney. I think that the better and proper starting point is the ruling of Dame Janet Smith in Shipman, yes, which then led on to rulings by Lord Savile in Bloody Sunday and Sir William Gage in Bahamusa, all of which establish one point, which is that there is no set standard of proof in an inquiry. But in my submission, you are in a different position because your terms of reference set your starting point, which is May. And whether you say reasonable grounds to suspect, reasonable suspicion, real possibility may not matter, but that is the starting point. And the reason I say it's the starting point is that depending on your assessment of the evidence, you too can adopt a variable standard. There may be circumstances in which you may say that I am satisfied or it is likely. You are not fixed to that starting point, but it is you can go as low as that if necessary.
No, I understand. Geoffrey, the third matter is the application for permission to question witnesses, and I've got your application. Thank you very much. Just before we come on to the particular witnesses,
I'm not sure which application. You have a letter, I think, written by those instructing me. Is that right?
No, I have an application by Attorney General dated the 30th of September. Right.
Okay. Thank you. I'm afraid it's something that I've relatively recently come into. So, but I can make the submission this morning if you wish it to be made.
Okay. Well, no. I do, please. Just before we come on to the particular individuals, there are three of them: the Auditor General, the Governor, and the former Governor. We've heard evidence from the Auditor General. We're about to hear evidence from the Governor. But just looking at the Act and the principles, the application focuses on two things, really. Section 12 of the Commissions of Inquiry Act and the requirements of natural justice. I mean, what we would say now is the requirements of procedural fairness to those who may be accused or criticised in some way. In relation to the Act, Sir Geoffrey, the relevant section is not, of course, Section 12, it's Section 13. Section 13 deals with examination by witness, examination of witness by counsel, because that's the side note, and that says that omitting irrelevant words for these purposes. A barrister or solicitor authorised by the commissioners to appear before them for the purpose of representing any person, so far as the commissioners think proper, examine or cross-examine any witness on any matter which the commissioners deem relevant to the inquiry, and a witness so examined or cross-examined shall have the same privileges, etc., as if he were examined by a commissioner. So that's the relevant section. So that gives me a discretion as to whether to allow any questioning of witnesses. on the basis that any questioning may be helpful, may be relevant to the inquiry, and also helpful to me. That's the first point. And the second point in relation to procedural fairness, which you raise. In respect of the matters that you wish to question the three witnesses about, these are matters in which the elected ministers, whom you represent, who the attorney represents, the elected ministers criticise them. The Auditor General, the Governor and the former Governor are the objects of criticisms made by the elected ministers. So procedural fairness in ensuring that I am fair to witnesses applies to the Auditor General, the Governor and the former Governor. It doesn't apply to the accuser. It applies to the individuals that are criticised. So in respect of general principles, any further submissions on either of those?
Well, I don't think differ from you in so far as your analysis goes, but I don't think you can, with respect, ignore the fact that your inquiry is playing out in public in a very clear political context, which the minister's statements have drawn to your attention or sought to do so. And while there may be, from the point of view of your procedures, the points you raise of procedural fairness to the witnesses, there is a broader sense in my submission in which fairness to the elected ministers to be effectively represented in your inquiry, and Section 12 clearly means effectively represented. It means an adequate opportunity to, the word representation doesn't mean simply sitting passively, unable to influence your thinking, unable to affect your judgment on matters of acute concern to the participant. And in our submission, to be effectively participating in your inquiry must at some point mean having the opportunity to address questions to witnesses whose evidence is of critical importance to aspects of your inquiry which touch upon the ministers, their concerns and their interests. Now, as you know, the central focus of the minister's concern before you, which it goes back to almost every aspect of the inquiry that you've recently been conducting, is the conditions of service, training, capacity, resourcing of the public service. What the ministers say to you is that if you ask why there is no proper policy for something, no proper written policy that has been published and is transparent to the public, their answer to that is because the public service has not been in the habit, save sporadically, in following those kinds of practices. If you ask why was it not possible to design and execute pandemic relief schemes in the timescale that the emergency required with greater precision, accountability, transparency, the answer comes back to the diagnosis that the ministers have made in their lengthy statements to you in writing, that the policy formulation function of the public service, well, indeed, all four aspects of critical policy making, policy formulation, policy development, monitoring and evaluation, all of those four critical aspects of the policy function were diagnosed by the ministers on the basis of reports before you, disclosed to you as having been chronically neglected. This is something which is the center of the minister's submission to you. If you ask why a minister doesn't follow appropriate policy in a policy environment that guides his decision-making, it's because that environment doesn't exist. Now, why doesn't it exist? The ministers say not because of the elected institutions into which a great deal of attention has been devoted, but because those responsible for the conduct, stewardship, training, discipline, modernization and reform of the public service have not entertained it for years and didn't until 2017. Now, that is so fundamental, not only to your paragraph 2, 3, and 4, but it's a relevant factor to your considerations on paragraph 1. What may be evidence of something in a UK context may well not be evidence of something in this jurisdiction, because in a UK context, your expectations will be conditioned by certain basic expectations of how matters would run. Let me give you another example. It's a fundamental fact that the attorney has attested to you in her evidence that the record keeping of the public service isn't methodical, isn't scientific, and at times isn't even coherent. You've suffered from that. We've all suffered from that, and in the course of your inquiry. Now, again, the absence of records might well, in a different jurisdiction context, give you to have some anxiety. But in this jurisdiction, with respect, it's not unusual. Now, there have been exacerbating factors. So we say that this fundamental question of the condition in which the apparatus and infrastructure surrounding democratically elected ministers are able or forced to do their jobs is of critical relevance. And the ministers should be permitted to ask questions on these central questions that go to all parts and paragraphs in order to demonstrate that it is only, this is what I mean by the wider context, that it isn't only the elected and local institutions that you are here to inquire into, but faithful to the terms of your oath and your mandate, into all aspects of the governance of these islands. And we submit, yes.
But that's right. And so when the Auditor General gave evidence on Friday, I largely through Mr. Rowett, of course, but I raised questions about VINPP and the publication of that report. And I raised criticisms because these had been raised by the ministers that she took a stance on the issues which you've raised, which is not an objective stance, and it's a political stance. Those matters were put to the Auditor General.
Yes, they were, and let me deal with that straight away, because I need to deal with that immediately. Of course, the questions were put, or at least some of them were put. But if your inquiry is to have the public have confidence of the public that it is genuinely looking into matters connected with the governance of these islands that lie at the door, not of the elected institutions, but others as well, it would be A, enhanced by allowing the minister's representatives to ask the questions, and B, it is extremely difficult when your inquiry has been, perforce no doubt, centered so much upon the elected and public officials of this territory. It does look as though the cross-examination or the examination of those has been pursued with a vigor and persistence that was not always apparent in the questions asked of the Auditor General. Let me be candid, and let me explain why. There are 5 broad areas that I wish to ask questions of the Auditor General. First, the language. My learned friend, Mr. Rowett, canvassed the question of the language used in the Auditor General's reports. And he put to the Auditor General but one word of that language in a manner that drew the sting of the real criticism. I mean no disrespect to Mr. Rowett, I know he knows that. He does a difficult job, being counsel to the inquiry, exceedingly difficult. But the fact is that the real word which the ministers deplored, and which is difficult, I would respectfully submit, to justify in an Auditor General's report, is the word falsify. Now, the criticism made in the minister's response, that is to say the Premier's office response, is that the various adjectival and verbal expressions used by the Auditor General leave no doubt in the mind of the reader that what she at least is leaving open as a possibility is that there was a quite deliberate attempt to falsify documents and claims. And the word falsify and the conjunction of the language that she used, which is the point made in the Premier's office response, namely inflate alongside falsify, the expression that is used in the document on the Premier's office's behalf, is there can be no doubt about the deplorable pejorative intention of that language when the word inflate is then used alongside the word falsify. Now, if one was putting, and I mean, as I say, no intent here to suggest that my learned friend's efforts were not entirely genuine to be balanced, and to some extent perspective was given by his questions, as was yours. But the real sting of that criticism is that an Auditor General would suggest of senior public officers in this territory that they had falsified claims. That in our respectful submission is worthy of further exploration. And the ministers watching on, and those who had witnessed this, and there are many, knowing of that language, would have wondered why it hadn't been put. Now, it wasn't put because counsel and you, sir, are overwhelmed. Well, not overwhelmed, but you are facing an enormous and complex task. But that is why, to deprive yourself of the opportunity, the tool that cross-examination can give, properly conducted, of course, is in our submission a mistake. And it's a mistake, if I may say so, that we've noted, I've mentioned before. I realize your time constraints are tough, but frankly, a tool, a cross-examination by another party or by participants is a tool that other inquiries use from time to time, and we'd invite you on this occasion. And let me just enumerate the other areas, if I may, for the Auditor General. The question of the publication of her report, which indeed both you, sir, and Mr. Rowett did address. But it's not clear from a review of the evidence she gave whether in fact she is now saying her report was published or was not. One might deduce from the fact that she said that she originally, in answering Mr. Rowett, she said she publishes her report on the website. If the minister doesn't do it, when the annual statements are published, you may recall this exchange of questioning between you, sir, and the witness, she publishes it on the website, but it only emerged a little later in response to Mr. Rowett's questioning that in fact the website had only been up since earlier this year. So the real question is, was it published or wasn't it published? Now that is important, because if it wasn't published, there is a question as to why the Auditor General said to you, and we say, and I would be putting it to the Auditor General, the effect of her evidence was clear beyond doubt, that it had been published. She went as far as to say, not only it had been published, but that a member of the public had come up to congratulate her upon it. So we want to know, and this leads to a much more serious point with respect, because the point is this. She told you, the Auditor General, quite understandably, that she was most concerned that reports of that kind should reach the public domain. Indeed, she used the expression, it shouldn't simply sit on somebody's desk. And she went on to say that, particularly with value for money reports, it was important the public knew of it. The question therefore arises, sir, what did she do about it? If the minister didn't publish it, and we now pretty certainly know he didn't, why did the Auditor General, first, what did the Auditor General do? Did she discuss it with the Permanent Secretary, whom she said at the time to be, I think, Dr. Potter? Did she raise it with the ministry, given the importance of these matters reaching the public domain? And let's not forget that the nature of her findings were very serious. And then that leads on to a further question. If the minister doesn't publish, and if at that time she wasn't, she didn't have a website, why did she not escalate the matter, as she told you on the 28th of June she could, by treating it as a Section 20 report? She told you on the 28th of June that she had a perfect discretion to decide that a Section 12 report should be treated as a Section 20 report. But it would appear that the Auditor General did nothing to bring that report to public attention. Now, the ministers are anxious to understand why not, because the Premier, as you saw, was confronted with that report and had not seen it. And there is I'm so sorry.
No, I'm sorry to interrupt. There are three other matters you say you want to raise with the Auditor.
Yes.
Could you briefly?
Yes, I can. The next broad heading is the timing of the report. Questions were asked about the urgency and the rush by you, sir, and by Mr. Rowett. But I think the ministers who instruct me are keen to understand the dates and times on which matters actually unfolded. For example, when did the governor ask her to audit these pandemic schemes? Was she first aware? Did she have discussions with the governor or anybody else about the timetable in which she should deliver her report to him? When was she first aware that you, sir, wished to hear her evidence on the 28th of June? And was she informed, to some extent she may have answered this question, of the ground her evidence was required to cover? These are relevant. Let me explain why, if I need to. The ministers believe that there is a possibility that these reports were commissioned, and there may be nothing wrong with this, directly in anticipation of your commission of inquiry. And that the purpose of the governor in making these requests was to ensure that at the time that you, sir, were going to hear the evidence from the Auditor General, those reports would be available to be adduced by counsel to the inquiry on the record of the inquiry. Now, if that is so, and it may not be, but those instruct me wish to explore the matter, if that were so, and if it did play a part in the reason why the Permanent Secretary was declined until the 28th of June to respond, albeit that the response may have been ineffectual, what we say about that is that if it were a part of her consideration, it would have been fair for the Auditor General to tell the Permanent Secretary that she was governed by a timetable that essentially was looking towards the evidence that she was to give before you on the 28th. Why? Because the Premier had made it abundantly plain to the whole of his government that the priority was to facilitate your inquiry. It would have almost certainly led to a change of conduct on Mrs. O'Neill, Dr. O'Neill Morton's behalf, certainly if she'd carried out the Premier's instructions. And it was if it were the case, and I'm not saying it's so it was, but the ministers are obviously, through me, expressing where their concerns lie. If it was not disclosed, then there may be a certain want of candor there, which needs to be canvassed because it may affect your view of the public officers concerned. Now, that's one area, that's that area. I also would like to ask her about the financial secretary's view. The former financial secretary, Mr. Forbes, who may recall telling you that in his view, the Auditor General should not generally be involved during the execution of a program, because the risk is that in making recommendations, she comes later to audit a program which she's influenced by those recommendations.
Is that the fourth?
That's the next one. The next one, sir, is cabinet policy. The auditor has consistently given evidence before you that a change of policy, once approved by the cabinet, could only properly be effected by the cabinet. We don't accept that. We say to you, and it may be that you want to hear submissions on it in due course, but it is open to a minister on good ground to alter aspects of a policy approved by the cabinet, where particularly if he believes and where he believes his colleagues will support the change. And as a political matter, of course, it's appropriate to return to the cabinet at some stage. We say Section 56 should be interpreted flexibly. Otherwise, the business of government just couldn't get done. There are many cases where a minister takes a view. We may well discuss it informally with the Premier, the Prime Minister, that a cabinet policy needs adjusting. Now, in this particular case, if that were so, we'd like to explore, sir, with her how it might affect her report. Because while it's quite understandable that she would look at the cabinet policy, in this case, there was clear evidence that the ministerial conduct of the ministry was departing from that policy. In our submission, and certainly at the moment, prima facie, we want to ask questions about how she regarded the change in policy, why she felt that it was only the cabinet could approve a change in policy, and also about churches, that there was a change on the 28th of September. So the final area relates to some assumptions in the report. Those instructing me found puzzling some of the answers about the schemes themselves. For example, she told you that you'd have to start such a program by building up the Department of Agriculture. So her starting point was that the proper way to go about running such a scheme would have been to equip the Department of Agriculture with the infrastructure, apparatus, and equipment to deliver it. Now, that raises questions about whether or not the assumptions she's applied to what are effectively emergency relief and stimulus schemes are really apposite in the circumstances of the times. There were other questions that, broadly speaking, there would be an area to do with the evidence of how she had applied assumptions in the production of her report. Those are the areas I want to cover. Had I been present, and I regret I wasn't, I'm afraid, sir, that on that day I wasn't available, and certainly not to rearrange my commitments as late as Friday morning. It may have been difficult in any event at the time you concluded for me to have concluded. I would say that probably I have an hour to an hour and a half of questions for the Auditor General. So that is the Auditor General, and in our submission, they are important to show that the ministers and the participants that a proper opportunity has been afforded to them to put their concerns and criticisms. It certainly wouldn't have been what would have been necessary had you, sir, and Mr. Rawat not embarked on the exercise, which case it would have involved substantially longer. But I would invite you, for those reasons, to permit the cross-examination. Insofar as the governors are concerned, of course, I shall have to wait and see how the questioning goes.
Yes. Well, can I just deal with the governors first, Sir Geoffrey, because I think that's
Yes.
easy, or at least short. I agree with that. It seems to me that the appropriate time to hear the application in relation to the governor, and no doubt the former governor tomorrow, is at the end of Mr. Rawat's questions, and then you can make submissions as you have now in relation to the
Auditor General.
And we can see, as it were, where we are. So in terms of the governor, we'll simply park that issue until sometime later today. In relation to the Auditor General, and I'll hear Mr. Rawat on this, but I'm hoping that we can deal with it fairly shortly. One point I would make, but I don't want to enter into a lengthy debate about it. It was very unfortunate that no one from the Attorney General's team was able to deal with this application as an application on Friday, because it would have been very helpful to have done it then. Even if we had not been able to conclude the Auditor General's evidence, hopefully we could have done, but even if we couldn't have done because of the hour, it would have been helpful to know where we were with the Auditor General. Secondly, given where we are in relation to the evidence looked at as a whole, I would be minded to allow you to ask your questions in relation to the matters you've identified. I would restrict that to an hour and a half. And what I'd propose to do, subject to anything Mr. Rawat wants to say, is to make inquiries of the Auditor General as to when she can come back and when she's able to deal with your questions, Sir Geoffrey.
Thank you.
The notice for that may be short, but we'll do what we can today to try and identify with the Auditor General when she can come back.
I wonder, I'm most conscious that your timetable needs to be observed, so it's not helpful now, but I wondered if I might just raise two ancillary points to give me an idea, because it may help me in judging whether I need to ask questions of both governors. First, is it your intention? It may not be, and I'm not seeking to load this question in any way, it's genuine inquiry. Is it your intention to seek, in some form or other, final submissions dealing with the inquiry as a whole and its the evidence before you, either in writing or orally, or both? In other words, what opportunities will the attorney have, and those represented to submit to you their reflections and focused observations on the evidence that you've heard? If you said to me you were minded to do that, it of course might make a difference to how my judgment about how I should conduct matters over the next day or two, because these points may be able to be raised and I may be able to be shorter. I may not, but I'm thinking aloud. Secondly, sir, clearly my decision as to whether or not, if you were to give me the opportunity to examine the governors, the governor and the former governor, may well depend on how much time is available to me. This is a theme of such central importance to the elected ministers that it will be no use my simply being given the opportunity to ask 10 or 15 minutes questions, whether when I may have for them is considerably longer. But we can address that later. But it would be helpful for me to know if you had, and it may be you haven't reached a decision on this, if you had in mind to how you might, so to speak, round up or complete your inquiry. And whether, I know that the attorney in particular is conscious that she's simply not had the time, but would like to assist you further. You asked her a little time ago on questions of governance, whether she had any recommendations or suggestions as to how matters could be improved. And I think as inevitably, as time has marched on, the evidence has become clearer before you, she may well have reflections on that she'd like to submit.
Can I just deal with that before we hear from Mr. Rawat? Firstly, in relation to the governor today and the former governor tomorrow, I think the protocol still applies, and
yes.
then in relation to any questions that you have for the governor, I would urge you at the end of each section of questions that Mr. Rawat puts to the governor, that you raise any questions for the governor then through him, through the protocol, which is still open to you. That's the first point. The second point is this. The governor's indicated a willingness to be asked questions by me through Mr. Rawat in the public interest. He's volunteered to respond to those questions. As you know, the governor is not compellable. He's because of Section 16 of the Evidence Act. I can't require him. I think uniquely in the inquiry, I can't require him as a witness to answer any questions, and we'll have to deal with that at the end of his questions. That may or may not be an issue in respect of any further questions that you may want to put to him. Thirdly, in terms of final submissions, I haven't come to a final view, but I've obviously given this some thought. We've dealt with some of the final submissions in inverted commas as we've gone along, and many of them have been very helpful. But we've dealt with submissions on certain aspects of the law and evidence as we've gone along. In respect of other aspects, I'm sure that I will request assistance on them, and it may well be that I'll need a little time to consider which areas, but those I can let you know about. What I'm less sure of is what I understand the attorney wants to do is, as it were, to make freestyle submissions. And what would be helpful in the course of the next day or so is if you were to let me know, Sir Geoffrey, of the very broad areas that the attorney may wish to make some submissions on. It may be simply as broad as she'd like to make submissions on, I don't know, the evidence on governance given by X or something. But that would help me focus on where final submissions could most usefully be made. And as it were, in the usual way, I would expect final submissions to be largely in writing, then with a fallback to oral submissions if required, which could then be relatively short. Does that help?
Thank you for that. Yes, indeed, it does. It helps a lot. Thank you.
We've kept Mr. Rawat out of this, Sir Geoffrey, but I'll just ask Mr. Rawat if he's got any comments on where we are in relation to these witnesses.
Can I deal with them in three parts? In terms of the governors, I agree that we cannot take those any further until my questions are finished. But I would, as you have done, Commissioner, encourage the submission of questions through me. We've done it twice before. It works quite well. A question can be emailed to those who sit behind me, and we can then consider. And if need be, if there need to be for discussions, then I can take 5 minutes and discuss it with Sir Geoffrey if necessary. Taking the Auditor General next. But making the general point, what's important is that representation and effective representation is not determined by Section 12 of the Act alone. We must always go back to Section 13, because Section 13 actually is the foundation for the rules that we have issued and the protocols that we have issued in terms of particularly the rules in terms of the process for questioning witnesses. It is not an unfettered right either to examine or cross-examine, and in fact I am bound by it as much as any other counsel involved in this process. It is only so far as you consider proper and on any matter that you deem relevant. Now, in terms of the Auditor General, there are now 5 matters that Sir Geoffrey wishes to canvass with her. The first is the use of language. The second is the VINPP report. The third is the timing of the COVID reports. The fourth is her knowledge of cabinet policy. And the fifth is certain assumptions in her report. I'm bound to observe that in relation to 3 of those, they do not form part of the criticisms that we asked others to submit to a witness. And I would be concerned that she's not placed, particularly because the Auditor General is not represented, particularly because she might have very well and have been entitled to have expected that when she came on Friday, her evidence would be concluded there and then, and she wouldn't be, as now is now emerging, be summoned back for more. And there needs to be a way found to make sure that she is alerted to what criticisms are being made of her. The linked difficulty with that, of course, is that she does not know who it is that is making those accusations, because they are based upon a report which we have been calling the Premier's Office report, of which I could not tell her who the authors are. They are a mix of officers within the Premier's office and, to borrow from Dr. O'Neill Morton, the many members of the IRU. It is also a report from which, at least in one instance, Dr. O'Neill Morton has resigned. And I am concerned that the Auditor General be treated fairly, which I'm sure you will ensure, Commissioner. But in terms of the ambit of further questioning, what I would explain or set out is this. On the date of the VINPP publication, the evidence that was put and canvassed with the Auditor General. On the use of language, that was canvassed in 2 ways. Firstly, in the specific, in that the specific criticisms that have been advanced on the by the Attorney General were put to the Auditor General, but also more widely in terms of her use of language. That was canvassed with her. What I also canvassed with her, not because it was it had been advanced by the Attorney General, although I'm bound to say it could well have been and should have been, was matters such as the timing of the report, as I understood it to be being put forward by the Honourable Premier in his evidence. I canvassed with the Auditor General the reason as to why she could not wait before issuing her report. I put to her Glenroy Forbes's evidence as to and Dr. O'Neill Morton's evidence as to the sequence of auditing that should occur in his view and in Dr. O'Neill Morton's view. I caveat that, although we did not put it to the Auditor General for good reason, is that it was accepted by Mr. Forbes, and as I understood it was accepted by the Honourable Premier, that the Auditor General has a right to initiate a report when she chooses, or to embark on a report when she chooses. And the advice of the attorney to Dr. O'Neill Morton was that there was no basis not to collaborate or cooperate with Auditor General. And so what the position we've reached, not least because there wasn't anyone here to put questions to her on the attorney's behalf on Friday, is that the question is whether it is necessary and proportionate to ask her questions. I hear what you say, Commissioner, as to what you're minded to do. And so I will only add this, that what I hope is that the questions don't go over ground that has already been covered and seek to unpick answers that have already been given. What you would be best be assisted by are questions that are intended to further your understanding of a particular issue, insofar as you deem it to be relevant to your inquiry.
Thank you, Mr. Wright. Sir Geoffrey, could I just 2 points that I hope you'll be able to answer to alleviate some of those concerns that Mr. Wright has. Firstly, my understanding from your submission today is that the areas of, let's call them areas of concern, that the elected ministers have are those that you've set out today. And I understand Mr. Rowett's point that these are not criticisms that have been, not all criticisms that have been previously made, but those are the areas of concern. You're on mute, Sir Geoffrey.
I do beg your pardon. Yes, exactly. Those are the areas I wish to cover.
And in relation to the point Mr. Rowett makes about who is making these criticisms of the Auditor General, the point he makes about a number of the documents which have been lodged by the IRU or otherwise on behalf of the attorney are not named, which has made life slightly difficult. But my understanding is that these concerns and criticisms are effectively made, they're made by the elected ministers, etc., the etc. being the other individuals, the other.
Well, as you know, Sir Gary, it's not uncommon in the United Kingdom for a ministry to publish its response either to a report, an inquiry, a select committee report. This represents, in effect, the ministry's response to the Auditor General's reports. Now, the Premier, as I understand it, I was not, I'm afraid, present for his evidence that I can recall, perhaps I was, but has adopted it and said it represents the response with which he has approved as the minister of that department.
No, I'm trying to make life easier rather than more difficult.
Yes.
Concerns and criticisms are effectively those of the elected ministers.
Well, they're those of the public officers and the ministry which the Premier presides over. But yes, they are agreed with by the elected ministers.
Okay, I mean, a problem, although hopefully it's not going to be, well, it isn't going to be insuperable. The problem is that these submissions contain evidence, they contain legal submissions, and it's not always
not legal, I think. With respect, not legal. They are points in answer to. I don't think there's any submissions of law in them, but what there are is expressions of opinion, expressions of view, and observations of argument, but they're not necessarily legal argument.
I accept that, but they contain evidence, and they contain, as you say, opinion, evidence, and views, yes. But without any indication as to whose opinion and whose views they are, which makes it.
Well, ultimately, the minister is responsible.
Well, that's correct. That is correct under Section 56, and that's the way that I've been proceeding in any event. So yes. The short answer is that these concerns and criticisms are effectively those of the elected ministers, and where documents have been prepared by ministries, the ministers are responsible for those documents in any event.
Yes, and as you know, ministers will always be assisted, even if they make an affidavit in their own name. It's most unlikely that the minister will visit the filing cabinets or otherwise ascertain for himself the facts. They'll be presented to him by his public officers. And so, just as in this case, It was the work of many public officers, as the Permanent Secretary said.
But I'm not sure that a minister has actually provided us with an affidavit, but if a minister were to provide an affidavit in respect of the COI, then we could ask him questions of that affidavit because it would be in his name. Our problem, and I don't really want to debate it because it's not at the moment helpful or constructive,
No.
but it's been a problem where we've had very lengthy documents and we haven't know who to ask questions, to whom to ask questions.
I see. Yeah.
We know where these criticisms of the attorney are coming, the Auditor General are coming from. And finally, and I think this is right, the application certainly does not make this clear. The application is based upon the elected ministers wanting to cross-examine the Auditor General, in this case, on matters in respect of which they criticise her. That's how the application's made. But my understanding of the application really is that it's in respect of matters which you've outlined today helpfully, where they see really potential criticisms of them, and therefore they're attempting to defend their position. And that, as I understand it, was another plank of your submission as to why these questions should be.
Yes, and of course the necessarily cumbersome procedure of criticisms. I mean, one could put them better in some cases, at least, certainly with the internal auditor, as disagreements, not so much criticisms. People can honestly disagree on matters without necessarily wanting to make personal criticism. Now, in connection with the Auditor General, they can be legitimately described, some of them, as criticisms. And yes, there may be criticisms of criticisms made of the ministers. So you're right, to some extent they are defensive.
Well, we'll proceed to Jeffrey in respect of the Auditor General as I've outlined. I'm quite sure that the attorney through you will deal with this cross-examination responsibly,
Yes.
not go over ground that is repetitious.
No.
We'll deal with the questions in a helpful way, that is helpful to me, and we'll make inquiries now of the Auditor General when she may be able to do that.
Thank you.
I raise a matter of practicality. I may be wrong, but I believe that Sir Geoffrey is presently outside the jurisdiction. So
right.
that may affect timing to some extent, but we will try our best to accommodate him.
I'm grateful.
It seems to me, though, that if the Auditor General is going to have to look at documents, then we would be assisted by some indication of what documents she'll be drawn to, because we will have to bring her to the hearing room, make sure that the bundles are here. If, for example, she's going to be directed to an answer that she gave, which is on the transcript, we'll need to make sure that that's available to her. And I wonder if we could have that information as soon as, because it may be that we can try and fit the Auditor General in
Quite soon.
as soon as soonish, so that we can get her dealt with.
Thank you. Sir Jeff, that's clearly sensible. So if you can identify really as soon as possible, or the IOU can identify as soon as possible those documents.
Yes. I don't think it'll be necessary to go to many, and chiefly the transcripts of her evidence. But we'll send a list.
But the transcripts of
evidence.
No,
evidence.
But of which day? Is just Friday, or when she gave it?
The 28th of June and Friday.
Okay, thank you. Well, that in itself, Sir Geoffrey, is helpful. As I say, we'll make.
And may I make another suggestion? If
Yes.
the transcripts are available of my remarks this morning, one possible way of alerting the witness to the potential criticisms would be to send her a copy of that.
Yes.
Yes, I mean, we can draw her attention to it. I mean, it depends on she may have other commitments. I mean, I think what would help though is if they were formulated in written form, so that they can be given to her in advance, so that she can have some sense of what she might need to prepare for. In terms of I mean, it's helpful that Sir Geoffrey has indicated that he may need to take the Auditor General to transcripts. We have a neighbourhood partnership project bundle. We have the COVID stimulus bundles. I'm sure at least one of those will contain the transcript from the 28th of June. And so we'll just need to make arrangements in relation to the transcript.
And they'll also include the VINPP report, the auditor's report.
That's in the
they'll include the various reports on the COVID stimulus grants.
Yeah, that's all there.
Good. Finally, Sir Geoffrey, and I think we can deal with this very shortly. With some regret, we can deal with it shortly, and that's the PII application concerning radar barges.
Yes, this is a matter on which I am going to confess shamelessly that I'm going to ask my learned junior, Mr. Risso-Gill, to deal with, who has had the opportunity to look at the detail on it. I'm afraid I'm not conversant with it. May I invite you to hear from him?
Of course. Can I just say this, Mr. Risso-Gill? I think
yes.
This very shortly. For one reason or another, and let me make it quite clear that I don't accept that the reason is the fault of the COI. The reductions in respect of the radar barges are simply not available. The application that was made, the Attorney General's application for PII, which was made on yesterday, is in a form which is incapable of being determined because it doesn't set out the reasons for any of the proposed reductions. The reductions only came in yesterday, and as I understand it, not even the attorney nor the IRU know the reasons why any reductions are being made, and therefore the PII application, and this is not the first in relation to this subject matter, these go back to requests made in August, but in any event, the application simply cannot be determined, and therefore what I would propose to do with great regret is to deal with radar barges in private session. I don't think we have any choice, but I can say this, that there will come a point when these issues concerning PII and proposed reductions will have to be dealt with by the attorney and will have to be dealt with properly. The application for reduction in relation to radar barges has been hanging around for a couple of months. I have never had an application in a form which has been capable of being determined, but there will come a point, notably when I want to put in information from these documents into the report, where the attorney is going to have to make a proper PII application. In relation to the application for this application, as soon as you are properly instructed, I would ask that application be made so that I can deal with it promptly and properly. But for today's purposes, and no doubt for the purposes of tomorrow and Thursday, I would propose going into private session to deal with the radar barge issues, because in my view, we simply have no choice. Mr. Wright, do you want to add anything before I ask Mr. Risso-Gill to respond?
No, Commissioner, it's safe to say that in my submission, if there is going to be an application for PII, we now have had two in a form that cannot be determined. But if there is going to be an application, it has to be made sooner, because the effect of a PII application is relevant material is not relied upon, and that will inform what use you can make of the material. So I would urge that it be done as soon as it possibly can be.
Yes, well, Mr. Russo-Gill, that simply underscores the importance of getting this application in properly as soon as you can.
Yes.
Anything else to add, Mr. Russo-Gill?
It's a question of, so you've dealt with the first point I was going to make, which was how to go forward, and that makes sense. The proposal that you have made makes perfect sense, rather than attempting to deal with the sensitivity of particular items as they arise, which would not be practicable. The second and third things I was going to do was to explain how we'd reached this position and what the position currently is. But it sounds like this would not necessarily be a helpful moment to do that for you. I hear and those that instruct me will have heard what you've said. Just one point to make. Yes. As I think you know, sir, this matter is with the National Security Council. We'd hope to have their decision before now. We don't have it yet in respect of their current approach to redactions. So that's one thing we're waiting for. The second thing is that you may have perceived this, although I know this has come to you at a fairly short notice. There is a difference between the redactions that were sought in September and those that are being sought now. It appears that the National Security Council are able to be less restrictive, or feel they are able to be less restrictive. But we, those instructed by the Attorney General and the IRU, have not yet had an opportunity to unpick the potential inconsistencies. And really, we take the view that it would be dangerous for us to extrapolate or infer what the National Security Council might have done with the September redactions had they been applying the approach they apply now. So there's that inconsistency matter, which I think my learned friend Mr. Rowett raised when dealing with this with Mr. Hyrie in September, that needs to be ironed out, if I can use that phrase. So there's both the need for the decision and an indication of the reasons on which the National Security Council wish for redactions, and then I shouldn't underestimate the size of the task. This is a 4,000-page bundle with numerous duplications within it. There needs to be a substantial job of ironing out that must be done to ensure that we have a consistent approach to this. So I simply outline what needs to be done so that you're aware of that, sir, in case any of that wasn't apparent. But I shall say no more for the moment, and obviously we'll proceed as you've suggested.
I need a properly formulated application.
Of course, sir. I didn't. Yes, I didn't miss that.
Understood that, but that is also an important.
Of course.
Good. Anything else, Mr. Wright?
No, Commissioner, but we've gone a little longer than we expected, but could I ask that you rise for 5 minutes so that we can set up the room and also give the stenographer a break?
Yes, we'll have a break now for 5 minutes, and then we'll move on to the evidence. Thank you very much. Good, thank you, everyone. We're ready to proceed. Just before we come to the evidence, Sir Geoffrey, in relation to the cross-examination of the Auditor General, that will take place tomorrow at 4 o'clock, maximum time an hour and a half. What I'll ask to be done, and I think this is technically possible, I'll ask the stenographer to expedite the part of this morning's proceedings when you outline the areas, because that will then save everyone time, and the auditor will know the focus of the questions. If you could let us have by 4 p.m. today any direction in terms of documents that you want to rely on, that too would be helpful. But the Auditor General has indicated that she'll be able to come here at 4 o'clock tomorrow.
Thank you.
Good. Thank you very much. Next, Your Excellency, Governor, could I just apologise for the delay? I'm afraid we do have delays from time to time. Legal submissions, they took a lot longer than we'd hoped, expected, but we are now ready to proceed. Thank you very much.
Thank you, Commissioner. Our witness today is the current Governor of the Virgin Islands, John Rankin. Governor, I understand that you wish to take an oath.
Yes, I'm happy to do so.
Do you have a Bible with you?
I do.
And do you have the words of the oath there?
I do.
Could you take the Bible in your hand and read out the words of the oath, please?
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
And for the record, could you give the Commissioner your full name, please?
My name is John James Rankin.
And your professional address?
Government House, Road Town, Tortola.
Thank you. You will see that on the table in front of you there are some bundles. I should warn you, they're not the only bundles that I might take you to today, but we will, as we go through your evidence, we may need to look at some of the documents contained there. Can I ask you, as I have done every witness, just to remember to keep your voice up and to speak slowly. It is obviously important that we keep an accurate record of your evidence. Could I start by asking you just to outline your professional background to the Commissioner before you took up your current role as Governor?
Thank you. Yes, I have a Bachelor in Laws degree from the University of Glasgow and a Master's degree in International Law from McGill University in Montreal. After finishing university studies, I qualified as a solicitor in Scotland and briefly practiced law there and taught public law and international law at the University of Aberdeen. I joined what was then the Foreign and Commonwealth Office in 1988 and have served in a variety of roles, both in London and overseas, including at the UK mission to the United Nations in Geneva, the British Embassy in Dublin, as Consul General in Boston, New England, as British High Commissioner to Sri Lanka, briefly as Acting Ambassador in Nepal, and then before coming here as Governor of Bermuda between 2016 and 2020. And I was honoured to be sworn in as Governor of the Virgin Islands on the 29th of January 2021.
Thank you. Before we turn to the role of Governor, but dealing with one aspect of it, you chair the National Security Council, is that right?
That is correct.
I understand that you may have been able to hear the earlier proceedings this morning, is that right?
That's correct, yes, I was listening to the proceedings.
Can you assist the Commissioner at all in relation to the present state of play in relation to the public interest application that may be made?
I can provide some information to the Commission. I heard the comment that was made from the colleague from, I believe, from Withers. The position is that as regards the latest papers, which I understand may be for consideration by the Commission, I was contacted by the Attorney General late on Friday afternoon with those papers and suggested redactions. I replied to the Attorney General with my view, which was that certain redactions might not be required, on Saturday morning, and that is where the matter was left as far as I'm concerned. So with respect to what was said, there is no paper on this subject and redactions currently before the National Security Council. Let me also, may I say, with respect, that I am concerned about the comments that were made by the IRU in relation to the National Security Council, because the National Security Council has not authorised the IRU to act on its behalf. The IRU is there to act on behalf of the elected government. So the advice I take on this matter will be with the Attorney General, who, of course, is an ex officio member of the National Security Council, rather than with respect with the IRU.
Just so that we can be clear, is it a concern for you that unredacted material is from the National Security Council is being shared with the IRU?
It is certainly the case that the National Security Council has made no decision that that material can be shared with the IRU. And that is not to cast any wrongful aspersion on the IRU, but I am concerned that if that is to be done, it should be done with the knowing authority of the National Security Council.
I don't think I can take that any further at the moment, but can I turn to the role of governor? You should see, and you may have a copy with you, but there is a bundle, I think, labelled constitutional and legislation bundle, which I think possibly is on the other side of the desk.
It is, thank you.
Yes, and if we turn that up, that contains the Virgin Islands Constitution, and it may be that by reference to that, you could explain the role of governor.
Thank you. As governor, I am empowered and constrained by the Constitution. So, under section 46(2), subject to the Constitution, the executive authority in the territory, I'm empowered to exercise as executive authority on behalf of Her Majesty the Queen. That's a general executive authority, but thereafter the functions of the governor are defined and therefore constrained by the Constitution. Section 60 in particular provides areas for which the governor has special responsibilities. And they are external affairs, defence, including the armed forces, internal security, including the police force, the terms and conditions of service of persons holding or acting in public offices, and the administration of the courts. There are other provisions of the Constitution which are relevant to the governor's powers, including, for example, under section 92 of the Constitution, power to make appointments to public offices and to remove and to exercise disciplinary control over persons holding or acting in such offices vests in the governor, generally acting in accordance with the advice of the Public Service Commission. And under the Constitution, section 49, I also chair Cabinet. I think in that last context, it's important that I should make clear that although the governor chairs Cabinet, the governor is not a member of Cabinet and does not have a vote in Cabinet, so no decision-making power in Cabinet. So the consequence is that if in Cabinet I express a concern over a particular decision which may be proposed, whether it be in relation to an appointment to statutory board, or a procurement or tender waiver issue, some of the issues which I know have been discussed in the Commission, I can advise on such issues. I can caution or encourage on such issues, but I do not have a say in the final decision taken. 2 other points, if I may. In line with what's stated in the 2012 white paper, the good governance of the territory and supporting and promoting the good governance of the territory is at the forefront of all that I seek to do as governor. And so, for example, I seek to support the independent institutions under the Constitution, such as the Auditor General or the Director of Public Prosecutions or the Complaints Commissioner, so that they can carry out their accountability functions. I similarly, in respect of Section 60 of the Constitution, always seek to support the Royal Virgin Islands Police Force and their work in tackling crime in the territory. And of course, in my work in Cabinet on the sort of issues which I described, I will give those issues as best scrutiny as I can to try to provide advice on good governance matters. And then lastly, I also, through my office, administer funds which are provided by the UK government for programmes and projects which we fund here in the territory. And the Governor's Office funds a number of programmes in relation to security issues, justice issues, environmental issues, work to support good governance and to support indeed the public service. In broad brush terms and in some specific terms, those are my functions under the Constitution as I see them. And in carrying out those functions, as I believe my predecessors will have done, will always seek to work cooperatively with the government of the day, setting out areas where we may disagree, but also seeking common ground wherever I can.
You've mentioned that you cannot vote in Cabinet. That's a limitation on your role as governor, but are there any other limitations on that role?
I am not responsible for the main financial decisions made by central government and by the Minister of Finance. So the funding which is provided to the work of the public service and the budgetary provision is decided by the government of the day, with the budget which is approved in the House of Assembly, rather than determined by myself as governor, subject to the exceptional power under Section 103 of the Constitution to order payments out of the consolidated fund for certain specified purposes.
Can I come back to 103 in due course? But you say you don't have a vote, but can you bring a? We've seen that different ministers and ministers will bring a paper to Cabinet. Can the governor bring a paper to Cabinet?
Yes, indeed. Yes. So matters which fall within the authority of the governor's group, which describes a number of the matters to which I've referred. Also, human resources issues related to the Civil and Passports Office, for example. I can bring papers to Cabinet on those subjects and make proposals for Cabinet to consider.
We know under the Constitution you have a deputy governor, and the evidence that the Commission has received is the deputy governor is the de facto head of the civil service. Can you take papers to Cabinet which are prepared by the deputy governor's office?
Yes, I can, and that is quite a regular practice.
And what sort of areas with those papers cover?
Usually matters related to the public service. So in relation, for example, to the recent memorandum of understanding, which I signed on behalf of the UK government with the Deputy Governor's Office on the training programme, that will go to Cabinet as a paper which has been prepared by the Deputy Governor's Office, and similarly work on public service transformation, which will be coming to Cabinet shortly, actually will be in the joint names there of myself and the Premier, with the Deputy Governor having contributed substantially to it.
One of the points that's been made in submission on an earlier day, when one is looking at the decisions that ministers take in Cabinet, that what has to be borne in mind is that firstly, there is a governor sat there chairing the Cabinet, but also that what was said was that governors have sat in Cabinet for 20 to 30 years and done nothing, which feeds to a point that I want to explore with you, which is the extent to which the governor or the UK government has assisted the Virgin Islands. But would you accept that as a fair definition of the governor's role, to sit there and do nothing?
No, I wouldn't. The job of the governor outside the areas which fall specifically under his or her responsibilities is to chair Cabinet in a way which supports the UK obligations towards the territory and supports the wider goal of good governance which I outlined. And I do that in terms of advice, in terms of support, or in terms of exercising caution or sometimes disagreement, depending on the issue of the day, and discussing those issues in Cabinet. And I'm confident that my predecessors as governor will have done the same. The governor does not merely sit as a figurehead in Cabinet, but can engage in discussion with members of Cabinet to hopefully assist in reaching the best interests of the territory in its decisions.
Leaving aside the limitations, it's still right to say, isn't it, that any governor would have a significant role to play under the 2007 Constitution?
That is correct, but the governor's caution or advice can be overridden by Cabinet on any matter which does not fall within the special responsibilities of the governor.
So that's the Section 60 responsibilities.
That's correct.
You say that, so on any other matter outside Section 60, your advice can essentially be ignored?
Not entirely. So, for example, in relation to public service appointments, where acting on the advice of the Public Service Commission or the Police Service Commission, those points lie with the governor. Section 60 is a primary provision in that respect.
But to whom would you be accountable as a governor?
I'm accountable, well, to Her Majesty, but to the Secretary of State in the United Kingdom for my actions as governor. And I am also accountable under BVI law for the actions I take. Governors do not have diplomatic immunity within the overseas territories. So the ordinary law of the territory applies to me as it applies to anybody else. I'm also accountable under the Diplomatic Service Code and the UK Civil Service Code. I'm bound to comply with those codes. Those are publicly available documents, and if I'm in breach of those codes, then I'm subject to action under those codes. I'm also, of course, accountable to the Court of Public Opinion and to a free press. I support very much the accountability which a free press can bring in any democratic society.
But it is right, however, isn't it, that as governor, there is no obligation on you to come before the House of Assembly to answer questions put by members of the House?
That's correct.
Nor is there a commission, perhaps made up of elected officers and members of civic society, which monitors and evaluates the work of a governor.
No formal such body under the Constitution, yes, Mr. Howard.
So does it not follow that there is an absence of accountability under the Constitution for those most and to those most affected by the decisions that a governor can take?
I'm not sure that's correct. As I say, I am accountable under BVI law. Should I act in any way contrary to my obligations under the Constitution, I would certainly also be answerable to the Secretary of State in those circumstances. I also receive letters from those in different positions within the territory, as well as, of course, communications with the Premier and government ministers. So, for example, the Speaker has written to me on a number of occasions in relation to powers I've exercised under the Constitution, and I have replied to the Speaker accordingly. So I think there are different accountability mechanisms which hopefully can keep any governor following the proper course.
Taking you back to Cabinet then, can Cabinet operate as a forum in which the conduct of a governor can be challenged by elected officials?
I can certainly be asked questions in Cabinet and or the National Security Council about the fashion in which I exercise my role. And indeed, ministers have asked me about positions I have taken or decisions I've been taking, and I've been happy to try to answer their questions accordingly.
And you said, you mentioned finances. Is there a ring-fenced budget for a governor and for the areas of special responsibility under Section 16?
There is a budget allocated to my office, the Governor's office, for my British Virgin Islands government staff within my office, and for the residents, and for some of the functions which we carry out there. And of course, there are also budgets allocated to the Royal Virgin Islands Police Force, to the public service, and to the independent institutions under the Constitution, such as the DPP, the Auditor General, the Attorney General, the Complaints Commissioner. So there are budgets allocated to those different bodies, some of which I have responsibility for under the Constitution.
And do those budgets operate, as we've heard other budgets do within government? I think probably all budgets do within government, that a bid is made, the relevant officer goes before the standing committee. Eventually, I think the Cabinet decides the budget, which is then approved by the House. Is that similar to the arms of executive government under your umbrella?
Yes, that's my understanding. I mean, that process has actually been going through as we speak. But I think the description you've just made is correct. And ultimately, it goes to Cabinet and then goes to the House of Assembly for approval. Yes, thank you.
Now, you was sent, Governor, a warning letter, or what the Commission calls a warning letter. There should be a copy of that on the table in front of you. And if I can explain the purpose of warning letters. They have been historically described as salmon letters, but we've used the more modern terminology. Their purpose is to draw to the attention of an individual potential criticisms that arise from the evidence. Now, they are just that, and I've told everyone this, that they are just potential criticisms. They do not form either the provisional or concluded view of the Commissioner. In your case, there are no potential criticisms made of you, John Rankin, as Governor, but the Commissioner has a protocol concerning the making of criticisms which allow a participant to make a potential criticism of another. And in this case, the ministers in the present government have raised criticisms of the UK government, criticisms of the FCDO, and of previous governors. And you, as the current governor and the representative of Her Majesty, in this jurisdiction are being asked to respond to those. And the reason for the letter is to do so that you are treated fairly. Now, you have, as others have done, taken the opportunity to provide a written response to the Commissioner, together with some additional documents. Now, the warning letter is confidential, but as to the written response, can you confirm that it was provided under cover of a letter from you dated the 14th of October 2021 and carrying your signature?
I can so confirm, yes.
And are you content that that written response with its accompanying documents can stand as part of your evidence to the Commission?
Yes, I am.
Now, I would like to take you through the criticisms and your response to them. But I want to do it in a wider way, because there are a number of issues that I think need to be canvassed with you. And so as we go through, if you want to refer the Commissioner to a particular part of your written response, by all means do so. But the first point that I'd like to explore with you is this concept of a modern partnership, which one finds referred to in position statements from different actors interested in governance. You see it in the documents. The starting point, I think, I would say, should be the Constitution. And do you agree that in exercising your powers as a governor, you have to keep in mind the preamble to the Constitution?
Yes, I do.
And in particular, what that preamble does it not, is we go to it. It recognizes, doesn't it, that the people of the Virgin Islands have a free and independent spirit and have developed themselves and their country based on qualities of honesty, integrity, mutual respect, self-reliance, and the ownership of the land, engendering a strong sense of belonging to and kinship with those islands.
Yes, it does.
It accepts that the Virgin Islands should be governed based on adherence to well-established democratic principles and institutions. And this is the point I most want to draw your attention to, and tell me if you agree or disagree. It affirms that the people of the Virgin Islands have generally expressed their desire to become a self-governing people and to exercise the highest degree of control over the affairs of their country at this stage of its development. And then it notes that the United Kingdom, the administering power for the time being, has articulated a desire to enter into a modern partnership with the Virgin Islands based on the principles of mutual respect and self-determination. Now, those principles, they may not hold any legal force, but they must surely be principles by which you must be guided when doing your work as a governor.
Absolutely. I mean, obviously, the preamble is important context and important for the interpretation of the Constitution, and indeed those provisions are in line with Section 73 of the United Nations Charter, which requires administering powers of non-self-governing territories to develop self-government according to the particular circumstances of each territory and its peoples and their varying stages of advancement. And it also, Article 73, also requires administering powers to promote the well-being of the inhabitants of their territories and to ensure their just treatment and their protection against abuses. And so I read the preamble and the provisions of Article 73 as being a consistent whole.
And there we have also, or the Commissioner has heard evidence or received evidence in relation to the white papers that were published by the UK government in 1999 and 2012. I think you've touched on the 2012 paper, but the substance of those, or one important point of those papers, is that the UK government committed to a modern partnership.
That's correct.
The Virgin Islands did not.
I mean, Governor, these strands one can see in the preamble to the Constitution. but there are a number of strands of that commitment, if I can put it that way, in Article 73. There's I'm just looking at the Constitution, that's because they're reflected here, but there is a strand that the people of the BVI in these circumstances should be granted as much self-autonomy as they wish to have and are able to have. There's a strand, and I'm not quoting from the Article 73, but there's a strand that steps should be taken to enable the people of a non-self-governing territory to move towards further self-determination and, if they wish, independence. There are a number of strands within Article 73. As I say, I think they're reflected in the Constitution. And certainly in some of the evidence we've heard, I'm sure Mr. Rao will go through some of this, the commitment of the UK government and the governor from time to time, the commitment of the UK government and the governor to those commitments, I think, has been questioned. What is your view about these commitments?
Well, I agree with the broad description you've made, Commissioner, that it is for the governor and the United Kingdom to promote self-governance and to promote the territory on that path, and that will sometimes mean advancing the capacity of the government in those areas, and as constitutions develop, sometimes giving further powers under new constitutions, as happened in 2000.
Is that in volume 2, Governor?
It is. I've got it at page part 1. I have
In 626.
Yeah, page.
It just starts at 624 is where it starts.
So the white paper sets out the principles which Commissioner Review just described. But it also sets out, for example, at page 634 in the bundle, it's page 9 of the white paper, where it says, making government work better. The government has responsibilities towards the people of the territories and of the United Kingdom. This is a BVI government. Sorry, let me start again, if I may, please. The government has responsibilities towards the people of the territories and of the United Kingdom to ensure the good governance of the territories. The government acknowledges the sensitivity of these areas of work, but believes that those living in the territories have a right to expect the same high standards of governance as in the United Kingdom, including in the areas of human rights, rule of law, and integrity in public life. The government expects high quality public financial management and financial services regulation as important contributors to building resilient economies and providing for the well-being of territory communities. The UK is determined to tackle corruption in all its forms, and the United Kingdom is committed to working closely with the territories on these issues. So, while supporting self-governance, it's also the job of the United Kingdom to, whilst recognising sensitivity, sometimes to tackle these areas as well.
Sorry, because I have a question, but we'll break for 5 minutes so that hopefully the internet can simply be reset and we can proceed on a firm foundation. Thank you. Thank you, Mr. Peters. I think we're ready to proceed. Just for those people who are looking at this by way of live stream, there was some instability in our internet connection, which we hope has now been resolved. Governor, I was just looking at Article 73 and the Constitution. They sort of seem to run in parallel very much, and no doubt understandably. The preamble to the Constitution emphasises the desire of the people of the BVI to become a self-governing people. We know that under Article 73, the UK government has an obligation to assist them in that, but to do so in a modern democratic way, if I can put it like that. There is a reference in the preamble to the Constitution to democratic values and social justice, economic empowerment, so on and so forth. So that's the context. Some of the questions I know, because these are the essential criticisms, cast doubt upon the commitment of the governor from time to time, the UK government, to the obligations really under Article 73, but also under the Constitution. And we'll deal with those questions as they come up. But can we start from this as a base point? Do you know of anything which suggests that you as governor and or the UK government, insofar as you can speak to the UK government, do not consider that these commitments are full and unequivocal?
I agree that those commitments are full and unequivocal.
I mean, as I said, you'll be asked some questions as to what's happened in practice, but the starting point is that, so far as you're aware, you and the UK government are fully and unequivocally committed to these obligations.
That's correct. Certainly, obviously the Article 73 obligations, which are legal obligations, and the preamble provisions will always guide what I will seek to do as governor.
Okay, thank you very much. Yes.
Well, but picking up on that, Governor, it's the reality gap, isn't it, between warm words and action. And what I'm going to take you through is a series of topics which, if the Commissioner accepts other evidence, will lead to the conclusion that the manner in which the UK government conducts itself in relation to the Virgin Islands, and particularly in relation to elected officials in the Virgin Islands, is not one that is indicative of a modern partnership or indeed mutual self-respect. And to start that off, if you look please at page 111 in that bundle.
Oh.
111.
111, which seemed to relate to the Recovery Development Agency.
Yes, and paragraph 16 at the top. Yes.
Thank you. Yes.
Yes.
Okay.
Now, what I've taken you to is a page in the position statement of the elected ministers, which you will have received and you have provided a response to. I'm drawing your attention particularly to paragraph 16 to 21, which you're familiar with, but I want to summarize it. But it is an immediate example of what may be said to be a lack of commitment to a modern partnership, because what that position statement sets out is that when offering a loan guarantee in the aftermath of the hurricanes of 2017, the UK did so by imposing conditions on the BVI, conditions which were suited the UK government's interests, but placed unnecessary constraints on what the BVI could do. Are you familiar with the circumstances in which the loan guarantee were offered?
Not directly familiar, because obviously I wasn't in office at the time, but I'm aware from the papers of some of the background to that issue, yes.
But would you accept that there is substance to the argument that in offering that loan guarantee, the UK government essentially put itself first rather than the interests of the BVI?
No, with respect, I wouldn't accept that proposition. What the UK government was seeking to do was to further assist BVI in the hurricane recovery process. So immediately after Hurricane Irma, the UK provided a very large amount of support to the territory, both in terms of immediate military assistance and policing assistance that was given, and then in relation to the wider recovery programme to help to restore electricity, to help to restore water, to help to provide emergency housing, emergency repairs for the territory. And I can give you figures on that if wished on the broad amount of expenditure in that area, Mr. Howard.
Can I come back to you?
As regards the loan guarantee, the purpose of the loan guarantee was to allow BVI, as part of its self-governance, to be able to have more favourable terms than it would otherwise have in borrowing money on the international markets for the recovery phase. And by having that UK backing on the loan and a guarantee that in any case of default, the UK would guarantee that role, that would have allowed BVI to obtain a loan at lower interest rates up to the offer of a 300 million loan. The conditions which were placed on that loan guarantee were absolutely standard. They are the same conditions on loan guarantees as the UK government has provided in other circumstances. They are standard terms and conditions. They were not exceptional or made exceptional for the British Virgin Islands. And it was ultimately, of course, for the BVI to decide whether or not to accept that offer of loan guarantee. And the government has to date not accepted that offer. My understanding is that the government did go out and seek a loan on the international markets. It got that loan at approximately 4% interest rate. I think it would have been possible to get a lower interest rate at that time had the loan guarantee be taken up. But I am glad to say that the government has since refinanced that loan and been able to take advantage of the lower interest rates currently available on the market, thus making some saving. But I think an earlier saving could have been made had the government chosen to take out the loan guarantee. But that was a choice for the Virgin Islands government to make, not for the British government to dictate.
But with respect, Governor, that may be said to be a rather rosy impression of what happened, because if one looks at the detail of the position statement, there are a number of things that flow from that. Firstly, for example, the creation of the Recovery and Development Agency. And so you have the creation of a statutory board in which all recovery funds will go, irrespective of where they come from. They will go there. And that board, perhaps uniquely when one compares it to other statutory boards in the BVI, that board had UK government input on it. The UK government could appoint people to it. UK government could influence what direction it went in. So that's one example. Take another one. Protocols for effective financial management. The effect of that was that the BVI government found itself in between a rock and a hard place, because if they wanted to borrow, they would be breaching the protocols for effective financial management, at least for some temporary period. But the attitude of the British government was that things were non-negotiable, that the conditions that were imposed from the beginning were non-negotiable. And take one more. I want to take you to, please, to 176 in the bundle. Now, what I'm taking you at 176 is to what's described as the high-level framework for UK support to BVI hurricane recovery. So that formed the initial framework by which discussions were held in relation to this loan guarantee. And even though the loan guarantee was never taken up, the RDA was put in place. And one of the other features that the UK government demanded, you go 177, at the bottom there, divestment of public assets which sit better in the private sector. Now, look at those three together. UK government wants all funds in one place and wants to exert control over it. UK government essentially takes the stance that it's a take it or leave it stance. This is not negotiable. And you will have to work within the protocols for effective financial management. And then UK government is telling the BVI, you have to sell off your assets, which collectively, or even in isolation, amount to a fundamental encroachment on the BVI's autonomous financial and economic policies, doesn't it?
Certainly.
And those are the kind of conditions that the government did not need, your government did not need to impose on the BVI.
They certainly provide a framework within which the UK government was asking the BVI to operate if the UK government was to provide that loan guarantee. So to take it back to the protocol of effective financial management, that protocol and similar protocols are in place with a number of overseas territories. In fact, I think I'm correct in saying in this region, all with the exception of Bermuda, and those are memoranda of understanding, which are entered into voluntarily by both sides to assist the territory in maintaining debt ratios and maintaining liquid assets which keep a sustainable economy. The Recovery and Development Agency provisions were designed to set up an executive body which would specialise in the recovery and development of the Virgin Islands. And the UK committed to co-funding the whole operation of the RDA for a 3-year period up until March 2021 of this year, and has done so to the tune of, I think I'm correct in saying, $5.8 million. But in terms of a loan, which United Kingdom was going to also offer, in addition to the help which hasn't been given, in addition to some £13 million worth of projects which have been developed through the RDA, was subject to certain conditions. And yes, I accept that as a framework which the UK government was seeking to require if that loan were to be given. If the counter proposition, Mr. Rawat, is that the UK government should have offered a loan with no conditions, then if the denial of that is a denial of self-governance, then I think it's an argument which obviously has its limitations. It would be reasonable for any government providing loan money to have provisions around it which would ensure the proper use of those funds.
But doesn't it take us back to two things? Fundamentally, that in this partnership, however modern you want to describe it, the UK government has the upper hand. You said earlier that when responding to questions from the Commissioner about the road to self-governance, but at any point, any step of that road, the UK government can say, no, you can't do that. That's the sort of trump card in the back pocket, isn't it? That you can have, as you do in the BVI, a vibrant political process, political parties that campaign in the open, elections that people can win or lose, and people who come into government and can point to a mandate. And yet, whatever they wish to do, there is always an element of the big brother. There is always an element of someone who can say at any point, you can't do that because we don't think that amounts to good self-governance.
Well, subject to an overriding parliamentary legislation in the UK on order in council, it's the constitution which governs the relationship. And the elected government is self-governing in all the areas under the constitution, save those which are reserved for the governor. So this territory has a large degree of self-governance. That level of self-governance varies between different overseas territories. So Bermuda and Cayman are perhaps the most self-governing of the overseas territories. And I hope BVI can move down the road towards further self-governance. But at the moment, the Constitution sets out the limits of where that self-governance lies. But it is a largely self-governing territory, and my job as governor is to support that self-governance. And it was the job of the UK government under my predecessor to support BVI following the horrors of Hurricane Irma, to help to support the recovery of this territory. And the UK has done so to a considerable extent. And the loan guarantee was intending to assist BVI in borrowing funds to more favourable rate of the international market, which I believe would be the interest of the territory. But it was for the territory, as a self-governing territory, to choose ultimately whether to accept it or not, and it chose not to do so.
I want to press you on this, because the point is, it takes back to the point you said to the Commissioner, that leave loan guarantees aside, but that the BVI can proceed along the road to self-governance. You've described it as a territory that has a large degree of self-governance already, but it's right, isn't it, that, and you can say whether it's under the Constitution or not, but that at any point, the decision as to whether something is a good piece of self-governance or a good step to take on the road to self-determination is the final word sits with the UK government, doesn't it?
No, I think it is constrained by the Constitution, Mr. Rawat. So there are steps taken by the elected government, many of which I support and welcome, but on occasion there may be steps taken which I do not welcome and which I do not think are necessarily in the interests of further development of the capacity of the territory. But in those circumstances, all I can do is to advise on the matter. I cannot override, and it would require a unilateral change in the Constitution or a legislative act from the UK to prevent that happening. So I think that does create a limit on what the UK government does, save in extraordinary circumstances.
So are the in terms of the Constitution, there are two aspects, I think, from that answer. Firstly, the elected government have their areas of function under the Constitution, and that's for them to deal with. That's the area of self-government. There may be issues that the government or the UK government impinge on those areas, but that's a different question. But the elected government have its areas of responsibility, which you accept cannot be properly infringed. The other way in which I suppose the UK government could prevent movement down the road towards further self-determination would be not to allow a new constitution which would increase this area of self-governance.
I think that's right, Commissioner. So the Premier of the government has proposed a constitutional review, and certainly I as Governor, and I'm confident the UK government will be happy to consider that review to see whether there are further areas in the Constitution which could be revised further down that road of self-governance. And where they are, they would certainly have my support.
So the constitutional review, one of the elements of the constitutional review, which I suspect is going to be quite sophisticated, but one element will be to look again at the relationship between the elected, democratically accountable elected government on the one hand and the governor/UK on the other.
That's right. I mean, there are some common provisions which are found within the constitutions of virtually all of the overseas territories. So they will tend to reserve to the governor ultimate authority for security and for external relations, save in specified areas. And the constitutions will seek to guarantee the independence of the courts. But otherwise, within those sort of set limits, I think there is room for discussion and room for development in the interests of self-governance.
And on the path to self-determination, that is something that I guess is going to happen from time to time for any territory. There would need to be a discussion as to whether, as to where, as it were, the territory was on the path, and whether now is an appropriate time to readjust that relationship to move further down that path.
That is correct. So there have been recent adjustments to the Cayman Constitution, for example, in line with what you've just said, Commissioner.
Thank you. Thank you.
The other point I wanted to pick up on is that isn't there an inherent difficulty for any government? Inherent difficulty for any government, because you are, for want of a better phrase, the FCDO's man on the ground, but at the same time it falls to you, I assume, to represent the interests of the BVI to the UK government. But doesn't it logically follow that those are just two mutually incompatible positions? One must prevail, and what prevails is always the position of the UK government.
Well, being a governor isn't always easy, because you're absolutely correct. On the one hand, I am sometimes representing a view from the FCO to the territory here, but on the other hand, I bat for the territory in its interests where I can do so. So, for example, in relation to the island's financial services, which are vital to the economy of this country, I, of course, support the need for the financial services here, like in any other jurisdiction, to comply with international requirements and to meet modern demands for transparency. But I will also defend to the hilt that where BVI's financial services are meeting best practice and where they are compliant with international regulations, then we need to support the financial services in this territory. And I will certainly make representations to the UK if I believe there are proposals being made which would act against the legitimate interests of the territory. So yeah, it's sometimes said that governors wear two hats, but I am certainly prepared to go for bat for this territory. And so, you know, for example, in relation to the cruise ship sector and developing further tourism in this territory, to the extent it's the largest devolved area, but to the extent that I can assist in that matter as governor, which will help the economy and help employment in this country, I will always do so.
Well, picking up on the point of financial sector, I mean, one area of concern that has been flagged up to the Commissioner is the position on publicly accessible registers of beneficial interest, because the point that has been made in position statements put before the Commissioner is that the UK government has required of the BVI and of other overseas territories a standard which requires them to go above and beyond the standards currently in place and operating across the world. I mean, that is indicative, isn't it, of yet again the UK government overreaching?
I think you're referring to possibly to the UK Parliament rather than the UK government, because the amendment to, I think, Section 18 of the Sanctions and Anti-Money Laundering Act was one that was passed by the UK Parliament. It was not one that was proposed by the UK government, and that refers to the preparations of a draft order in council, which would require publicly accessible registers by 2023. I'm pleased to say that all of the overseas territories, although BVI was last to the table on this, have given undertakings in this respect, which has meant that the UK government has not legislated in that area. But I believe it was a wise decision of the BVI to come forward in this area because of the greater demands for publicly accessible registers, which aren't going to go away. I note the reference you've been made to a global standard, Mr. Rawat. I'm aware that the statements made by the BVI government refer to that global standard, but I nonetheless believe even short of a wholly global standard, which the UK is advocating, that would be a wise move, not least because I believe that publicly accessible registers will be required under the EU 5th Anti-Money Laundering Directive. And if BVI and other overseas territories don't move in that direction, I believe it will have adverse consequences for the territory. But in terms of batting for the BVI, what I will continue to point out, and what I have continued to point out, is that under the information, under the exchange of notes with the United Kingdom government, and under the so-called BOSS system, BVI is possibly best in the world in terms of sharing information with the law enforcement agencies when they're making inquiries into anti-money laundering initiatives. So I back for the BVI in best practice in that area, while also encouraging the BVI to accept the requirements of greater transparency for publicly accessible registers. So I think it's a good illustration of the two hats the government has to wear.
But take the first, you say you commend the BVI for exchanging information under the BOSS initiative, but that is sharing information so that law agencies in different jurisdictions can better tackle things like money laundering. That's one thing. That doesn't require a publicly accessible register, does it? It requires mechanisms by which you effectively share information between different jurisdictions. Would you accept?
That's correct.
But on the other side, the point I'm trying to make to take you back to the question is that requiring the BVI to go further than necessary is an example of UK overreach, because it's not allowing the BVI to decide for itself that it will take this step. It is saying, because we have determined what transparency should be, you must now take this step. And it's not holding a carrot over their heads, it's holding a stick over their heads.
Well, let me repeat, this was a decision of the UK Parliament rather than the UK government, and I think it is a pertinent distinction here, because it is the government that has the obligation, for example, under Article 73 of the Constitution. Secondly, I don't think it's so much a matter as holding a stick over the head of the government, rather supporting BVI and encouraging BVI to meet the relevant standards. And even if it does not become a global standard, it is a job, I think, of myself as governor, and I've done this in discussions with the financial services sector here, is to say, I recognise you don't like this, and that there's some opposition to it. And I need to be circumspect here, Mr. Rawat, because I know there may be an internal legal challenge, a domestic legal challenge here on this issue. But my frank advice has to be the demand for publicly accessible registers, irrespective of the position of the UK Parliament, is not going to go away. And it's not in the interests of the BVI to find itself blacklisted by the by the European Union under the 5th Anti-Money Laundering Directive. And so while I recognise this is not a popular position to be taken, I think it is my job as Governor to recommend to the BVI that they move in the direction which is sought by the UK Parliament.
Governor, you've raised the distinction between the UK Parliament and the UK government, which obviously I understand. So, but this stick, if it was a stick, was an act of the UK Parliament.
That's correct.
And I put this bluntly, and you may put it more elegantly than this. So effectively, you had no choice in the matter, because it was the UK Parliament which is ultimately responsible for the territory.
That is correct, and so long as.
But I'm sorry. Let me. But as I understand your evidence, you see the advantages. There may be disadvantages too, but you also see the advantages of compliance. But because it was the UK Parliament, no choice really. Is that fair?
Ultimately, it's correct that an order in council could be made under the Sanctions and Anti-Money Laundering Act, which could require this of the BVI, subject to any legal challenge that might be brought on the matter. And that, if you like, is a consequence of BVI remaining an overseas territory of the United Kingdom, because the sovereignty lies with the UK Parliament and the members of the UK Parliament. That is the position so long as the status of overseas territory remains and applies in relation to all overseas territories.
Yes, thank you.
Commissioner, before I move on to the next topic, I've been asked to put a question to the Governor on this issue. Governor, can you address this? On what basis does the imposition of a publicly accessible register of beneficial ownership, on what basis is the imposition of a publicly accessible register of beneficial ownership appropriate for the BVI in a sphere of devolved responsibility?
Thanks, Mr. Rawat. I'm again aware there's a legal challenge on this issue, so I'll be circumspect in what I say. But to the extent that this is becoming a requirement in the European Union, in the OECD, and internationally, the UK has an obligation to support the BVI in meeting international standards.
And just give us a sense of the timeline there. You've spoken of the EU more than once. I mean, what is the timeline for them beginning to blacklist countries, if that's what they're going to do?
I'm not entirely up to speed on the precise timetable, Mr. Rawat. This is an issue which I dealt with in greater detail in my last job, and I've dealt of late here because of other matters. But I believe that if by 2023 publicly accessible registers have not been introduced, then the risk of the EU taking a decision to blacklist certain jurisdictions who have not done so will increase. And we know that there are certain EU member states who have the overseas territories in their sights, as well as certain other jurisdictions. And I want to do all I can to help to avoid that happening. And therefore, the moves in this area, I think, will be of assistance to the BVI. That's certainly my advice to those with whom I've engaged in this territory.
In respect to the question Mr. Rawat asked about this actually being a decision within the devolved responsibility of the BVI elected government, perfectly reasonable question. And you say that you have to be sensitive because this may be the subject of a legal challenge. But if that may be right, if the UK Parliament, in this case, makes a decision that impinges upon a properly devolved area, that presumably then would be a matter, just hypothetically, that would be a matter for the courts to determine.
That's correct.
I mean, just as a general principle.
That's correct. I mean, my own view is that the UK Parliament has this authority, but if it were challenged, it would be for the courts.
Yes, thank you.
Before we move on, Governor, can you just break down in terms of you touched upon UK support in the immediate aftermath of the hurricanes, but I don't want that to get mixed up with the loan guarantee, which I canvassed with you. In the immediate aftermath of the hurricane, can you give the Commissioner a figure? Firstly, a figure for how much support the UK provided, and then the different ways in which you say the UK provided support to the BVI.
Yes, I can. If you give me just one moment to check my notes, please, Mr. Rabat. Thank you. I may preface my answer by saying that I myself visited BVI after Hurricane Irma and saw for myself the devastation which had been caused to the territory and the clear need for support after what had occurred. And I can give you some figures. So in terms of the immediate regional support to the territories which had been damaged by Hurricane Irma and subsequently by Hurricane Maria, and that was the BVI, Anguilla and the Turks and Caicos Islands, the overall immediate recovery funding provided by the UK amounted to some £72 million, including the cost of the military deployment and the support that was given for policing to help to restore law and order after the hurricanes had hit. In addition to that £72 million of regional funding, it's difficult to break that down precisely between the different territories. The UK provided more than £13 million directly for projects in the BVI, including emergency housing and repair programme, rebuilding the electricity grid, water and sewage, repairs to the prison, and provision of a temporary magistrates court. And since then, specifically for the Recovery Development Agency, the UK has provided, in addition to the projects we funded, to which I've just referred, provided, I think I already said 5.8 million, let me correct that please, $5.1 million in relation to the running costs of the Recovery Development Agency between its establishment in April 2018 until March 2021.
And was it 13 million?
13.
Was this a grant or an award, or was it a loan?
No, that was direct spend. Direct spend by the UK, either in physical support given, but in terms of funding of projects for electricity grid, water, sewage, and a number of RDA projects which the UK has helped to fund. And we continue to help to fund projects in that area.
What period of time are we talking about here?
The immediate support was spent in the immediate months after Hurricane Irma to respond to the immediate devastation. That £13 million programme has continued over a longer period of time. I can't break it down for you exactly at the moment, Mr. Arwat, but I could no doubt get you more details if required.
Commissioner, I've noted the time. I'm moving on to a different topic, so if it's convenient.
We could certainly break. We could certainly break for lunch, Mr. Rawat. We've had one or two breaks this morning for one reason or another. We'll break now, Governor, and we'll try and come back at about 2:05, and you needn't stay here.
Thank you. I think I've got a sandwich in the room next door, Commissioner. Thank you.
And we'll resume at 2:05.
Okay, Commissioner.
Good. Thank you very much.
Thank you.
been discussing in private session 3 documents over which privilege has been asserted, and Sir Geoffrey Cox is going to check as to why privilege is being asserted in respect to those documents, and whether it's being maintained. But we're now ready to proceed with the evidence. Thank you, Mr. Rowett.
Governor, can I turn to the next topic that I want to canvass with you, which is the responsibilities that are due to a governor under the Disaster Management Act of 2003, which is a piece of BVI legislation. Now, the Act is not in the bundles in front of you, but it's right, isn't it, that it imposes certain obligations on a governor to take steps during a disaster.
That's correct.
If I could just take you through some documents, just for purposes of setting the chronology and the background to what appears to be a dispute between, let's call it, the governor's office and the elected ministers. If you go, and we'll be jumping between bundle 1 and bundle 3, but if you go to please to page 885 in that bundle.
885 of bundle 1?
Yes, please.
Thank you.
I'm sorry, Commissioner, I didn't catch the reference. I wonder if Mr. Rowett could repeat it.
885, Sir Geoffrey.
I'm most grateful, thank you.
First bundle.
Thank you.
Thank you. I've taken you to a letter from Augustus Jaspert, your predecessor as governor, on the 4th of December 2020. And he sets out there, it's a letter addressed to the Honourable Premier, that his disappointment at not being consulted at the proposed machinery of government changes, namely the movement of the Department of Disaster Management from the Governor's Group to the Premier's office before they appeared in the budget. And he writes, this is not a partnership approach to governance. But what Mr. Jaspert then continues is that he says, as the law stands, the governor's responsibility for disaster management is made abundantly clear by the Disaster Management Act 2003, under which coordination of the government's general policy for disaster management is ultimately for the governor. And he says it's the governor's duty to prepare a comprehensive disaster management plan, make preparation for disasters. And that provides, therefore, under the Act, for the governor to be the person that appoints and supervises the director of the Department of Disaster Management. The argument that is made by Mr. Jaspert is that this falls within special responsibility for internal security under the Constitution. If we go in the same bundle to 199, yes.
Mm-hmm.
Give me a moment. Not in that bundle, but in the third bundle. Apologies.
Thank you.
We find on the 9th of December the Honourable Premier's reply to Mr. Jaspert. And he makes clear that he insists that we proceed with the administration of the Department for Disaster Management by the locally elected government, The Premier then refers to section 60, being clear in limiting the powers of the governor to those subjects in section 60. And he makes clear his view to Mr. Jasper that deviation from this constitutional prescription constitutes a breach of the Constitution and violation of the partnership between the UK and the people of the Virgin Islands. And he refers in support to international obligations under Article 3 of the United Nations Charter. And you yourself point that out. And then the Honourable Premier goes on to make a number of points. He rejects the suggestion that this should be a matter for the upcoming constitutional review. He points out that management of a catastrophic event is not solely and wholly a security matter. Making the point that comparing COVID-19 to the hurricanes is not appropriate. They're different types of disasters. And then says that while the UK government has provided support to the BVI during catastrophic events, and for this we are grateful, the BVI is ultimately responsible for our own preparedness, management of the situation and recovery. And something he says that was made very clear by Baroness Elizabeth Sugg during the COVID-19 pandemic. Now, we then go back to bundle 1 to 888, please.
Yep.
And there, Mr. Jaspert responds and says that his position remains unchanged on the Department of Disaster Management. This is a letter dated 18th of December 2020. He says under the Constitution and the Disaster Management Act of 2003, the governor's responsibility is clear. And then points to, given the position under the current Constitution and law, DDM and the subject of disaster management should be presented correctly in the budget estimates as being under the remit of the governor's group. Now, can you clarify, just to help us a little bit with what that means? In terms of, as I understand it, the DDM sat under the governor's group and therefore the governor had responsibility for its budget.
That's correct.
There was a proposal to move it to a different ministry, if you like. And what Mr. Jasper is arguing is that it should remain under the governor's group. Is that right?
That's my understanding, yes.
Now, if we go back to bundle 3, we will see that at 216, this is a letter from the Honourable Premier to Mr. Jaspers on the 18th of December 2020. The Premier responds and says that his position on the rightful and constitutional alignment of the Department of Disaster Management under the administration of the territorial government remains unchanged, and that the necessary legislative changes to support this realignment are the remit of the House of Assembly. They're not dependent on or contingent on a constitutional review, but that they legislative changes to ensure alignment with the current housing of DDM are before the House of Assembly. We then go in the same bundle, please, to 203.
Sorry, 203.
Yes, bundle 3, we're still there. The Premier then on the 14th of December, copying in all ministers and junior ministers, seeks legal advice from the Attorney General on the question of where the Department for Disaster Management should sit and who has responsibility for it from a constitutional point of view. Now, I won't go into the detail of that advice for reasons of that privilege may still be asserted over it. But if we go to 889 in bundle 1, we see that the current Deputy Governor, but in the role of acting Governor, on the 22nd of December 2020 writes on a memorandum, I've assented to the Appropriation Act 2021. Sorry, I'll read that again. I've assented to the Appropriation 2021 Act 2020, but clarify that in doing so, do not endorse any purported regroupings or movement of financial controls within the budget estimate, unless in line with current governance structures, and until these are altered through a proper lawful process, including where necessary assent to legislation reallocating responsibility. So could you just explain what the purpose of this memorandum was, please, if you can?
Obviously, before the period that I became governor, but my understanding was that this was essentially without prejudice statement by the acting governor. So he was willing to assent to the Appropriation Act, but that was without prejudice to the view on where the budget should lie in relation to disaster management and where responsibility for disaster management should lie.
Now, this does come across your desk if we go to page 249 in bundle 3.
Yes.
18th of February 2021, you write to the Honourable Premier, and you write, you say, with further thoughts about what is now the Disaster Management Act of 2021, but not an act, as I understand it, to which assent had yet been given. Is that right?
That's correct.
You say, I believe we agree disaster management is crucial for the Virgin Islands, and it's important that effective coordination exists between all parties with responsible for decision-making and delivery in this area. You continue that whilst it's an issue for all parts of BVI government, and you support a collaborative whole of government approach, it's ultimately the responsibility of the governor to ensure the safety and security of the territory. Disaster management impinges on internal security and external affairs, which are the responsibilities of the governor set out in section 60. Therefore, I believe it is necessary that a number of key disaster management policy areas should continue within the governor's group in order that I'm able to fulfill those constitutional responsibilities. The DMA 2021 represents a whole-scale transfer of policy away from the governor's group. You then mentioned that the governor's group was not involved in any consultation on the Act. You go on the next page to point to the significant constitutional issues involved, the key importance of ensuring responsibilities for effective disaster management are properly delineated, and you suggest that the matters raised in the Act would best be considered as part of the overall issues under the proposed constitutional review. If we then go to the first bundle on page 898, please. We're now on the 23rd of April 2021, again concerned with the Disaster Management Act. And you are following up on your letter of the 18th of February 2021. So just would the Commissioner be right to assume that you hadn't received a response to that letter of the 18th of February 2021?
I believe not.
You point again to the importance for effective disaster management. You refer to working in a collaborative fashion. The need for effective coordination and joined up working, and you say you're committed to maintaining that approach to best meet the territory's needs. You then refer once again to the responsibility of the governor to ensure security of the Virgin Islands. And you say disaster management clearly involves internal security and external affairs, which come under section 60. And you then continue by repeating what you'd said before about the importance of it staying with the governor's group. You conclude that the Act represents a major transfer of policy and power of direction away from the governor's group, and you say, accordingly, I would not be able to assent to the Act as currently drafted. And then you refer again to the opportunity that's provided by the constitutional review and ask the Premier to agree that the Act be redrafted as appropriate following the constitutional review. You then say, should you not be willing to agree to that approach, I will reserve the question of assent to the Foreign Secretary for his consideration. Last letter in the sequence, if we look at page 253 in bundle 3, the Premier responds to you. He begins by saying, I'm sure you would agree that the UK government should see it as a privilege to assent to a piece of legislation debated by members of the House of Assembly, elected by the people and for the people, and who represent the pure interest of Virgin Islanders, and which legislation has gone through the legislative process, inclusive of the scrutiny of the Attorney General and the Cabinet. He continues by saying, whilst it's clear that the UK government and the government and people of the Virgin Islands have differing views on major areas of policy and how they should be handled, and where the balance of power between the governors group and the elected territorial government should lie. But he then says, this matter is not about transferring power away from the governors group, but ensuring that elected policymakers are put in charge of policy and preparing the territory for facing any disaster that comes. As governor, you should see the advantage of this and be happy to assent to the express wishes of the House of Assembly. And then he goes on in the next page by saying that what not assenting to this bill really means for the Virgin Islands will be unfolded. He points out in his letter that he sees no difficulty with the Act as passed by the House of Assembly. It advances the Virgin Islands in the journey towards self-determination, and the letter points to Article 73 and the Constitution. And the Premier explains that in the process, this would gradually transfer power from the UK government and the governors group back to the independent spirited Virgin Islands people should be seen as an impetus rather than an obstacle. The letter points out that the passage of the Act was a decision of the legislators of the House of Assembly expressing individual and collective will as elected representatives. And the Premier says, it would not be prudent for me to exercise any actions that conflict with the express will of the legislative arm without first obtaining the consent of that arm, especially since constitutionally the Premier is accountable to the Parliament and not the other way around. He then concludes, as relates to your request for the Act to be redrafted following the impending constitutional review in order to avoid the unfortunate situation of the Governor exercising his prerogative and declining assent or having to place the final decision for assent at the feet of the Foreign Secretary, this is not a decision I'm prepared to make on my own as a responsible leader. I cannot speak for the legislative arms. And then the Premier says that where historically the position of the governor is usually upheld by the UK government, I'm inclined to seeking the guidance of the House of Assembly on a way forward with respect to your expressed position on the Disaster Management Act 2021 and your recommendation. Now, your recommendation was that the status quo should be maintained until the constitutional review. That was in April 2021. What's the present position in relation to the Disaster Management Act?
The present position is that the Act has not been assented to by myself as governor, and I've received no further correspondence from the Premier in response to his inclination to seek the guidance of the House of Assembly on a way forward. So the current situation that it was at the end of April continues.
You appear, in terms of your analysis of the Constitution and a governor's role in disaster management, to have adopted the same stance as your predecessor. Is that right?
Yes, it is. But let me be clear, if I may, Mr. Rawat. It is not argued by me, nor I think by my predecessor, that the Disaster Management Act is unconstitutional. What is argued is that it impinges on the responsibilities of the governor for security and external affairs, and then therefore falls within the interests of the governor. it involves those responsibilities. And I use that word involves, particularly given the wording of section 41C of the Constitution. So it's a matter which involved matters for which I'm responsible under section 60. And so in exercising my decision whether or not to assent, I consulted duly with the Honourable Premier.
But returning to a point I was making before the lunch break, I mean, what section 60 does not do is refer in terms to disaster management, does it?
That's correct.
And so is this not a matter of interpretation between yourself and the Honourable Premier? Leave aside whatever legal advice you might have been given or you might receive, but isn't the point that has been reached that your analysis of section 60 is that by combining external affairs and internal security, disaster management falls within the purview of the governor?
No, that's, with respect, not my position. The Disaster Management Act, which has been assented to, the previous Disaster Management Act, assigns responsibility for disaster management to the governor. The new legislation would involve a whole-scale transfer of that responsibility from the governor to the relevant minister. And so Director of Disaster Management would fall under the policy direction of the minister rather than the governor. And that transfer direction means those elements of disaster management which relate to security and external affairs, for which the director is carrying out day-to-day responsibilities, would be placed under the policy direction of the minister. I have seen nothing to suggest that the position taken by my predecessor and myself is unconstitutional. It's a policy discussion, Mr. Rowett.
But when, although it was a whistle-stop tour of the correspondence, but when we looked at that correspondence, the first point that was being made by yourself and your predecessor was section 60.
That's correct.
And so when one reads that, it's, well, actually, the starting point is section 60. I see section 60 as covering external affairs and internal security. That encompasses disaster management. It should be for a governor to lead on this.
My view is that disaster management so greatly involves responsibility for security and external affairs that for the time being, it should remain the responsibility of the governor.
But if we look at it through the other lens, the Premier's position is, or could be interpreted as when one looks at section 60, it makes no reference to disaster management. When you appreciate that in a disaster, there may be more than one ministry involved, and when you appreciate the importance of allowing autonomy and allowing the government of the BVI and the people of the BVI to exercise as much control as possible over their own affairs, it is logical, isn't it, for disaster management to sit under one of the ministries?
I think, Mr. Rowett, this has been a somewhat unfortunate debate, because certainly I, as governor, and I'm sure my predecessor, are committed to a partnership approach in disaster response. And indeed, the current structure of the National Disaster Management Committee provides for that partnership approach, which is jointly chaired by myself and the Premier, and involves a host of government departments, many of which the governor does not have responsibility for, including public works, for example, health and fire and safety. So it's essential that if disaster management is going to be coordinated properly, that involves a partnership and a whole of government approach. And that's certainly what and I'm confident for all the minutes I've seen my predecessor, have always sought to do. The structure of the committee which oversees this is a partnership, approach. But I've unfortunately had some responsibility engagement in disasters previously. I was in Nepal as the acting ambassador when the earthquake hit in 2009, which killed 9,000 people. We faced hurricanes, fortunately not disaster, during the time I was in Bermuda. And of course, I saw what happened in Hurricane Irma. And what I do know is when you face a disaster as great as Hurricane Irma was, first of all, it can raise serious security issues. Prisoners came out of the prison, there was a degree of looting, there was need to restore order following Hurricane Irma. So it involved security issues. An external support was required in terms of the British Naval and Ministry of Defence response and policing assistance, which came from Bermuda and Cayman. So the responsibilities of the governor in that disaster response for security and external affairs were intimately involved. And my view is that moving policy direction away from the governor to the minister would not be in the interests at this point in furthering disaster management in the territory. Now, I don't rule out there's room for debate in that area. It's a matter for discussion and negotiation. My understanding is that the Disaster Management Act, the latest legislation, the current governor was not consulted in any detail. So the previous governor was not consulted in any detail on that legislation. And as part of a constitutional review going forward, I recognise this is for discussion, but it's not something to be rushed. It's not something to be done without a great deal of careful consideration. And to be frank, I have discussed this issue since I came into the territory with others much involved in disaster management. And the view and advice I've received is at this stage, the belief is it would be better for the overall policy responsibility for management to rest with the governor rather than be transferred at this point of development. But I don't rule out further discussion in that matter. I'm not arguing this would be anti-constitutional. I'm arguing that at the moment, because it so much involves responsibilities for security and external affairs, it would be wisest for that overall responsibility to remain with the governor while working in close partnership with the Premier, the elected government and government departments for which the governor does not have direct responsibility. That's my best judgment of the matter.
That's helpful, Governor. Just to confirm the constitutional position so far as you're concerned, not the constitutionality of the Act, but you're not assenting to the Act. My understanding from your evidence today is that you consider it falls under Section 41C of the Constitution. Is that right?
No, with respect, no, Commissioner, that simply dictated my duty of consultation, because you will see that Section 40, paragraph 1 provides that the governor shall consult the cabinet in all of the functions conferred on him by the Constitution, except, and then little c is in any case which in his or her opinion involves a matter for which he or she is responsible under Section 60, hence the term involves being important. But in exercising my powers in relation to paragraph C, the duty is to consult the Premier, which I duly did.
Yeah. So I'm sorry, Section 40 is simply to explain why you consulted with the Premier and not the Cabinet.
That's correct, although the Cabinet, I think, were aware of my position.
But it takes us back to what I put to you as an imbalance in the modern partnership, which is that you can withhold assent to a bill, and you can also refer it to the Foreign Secretary, who, if one takes the Premier's letter, is more likely than not to side with his governor. And so that is, again, the ultimate sanction that sits with the governor.
That's correct. That's correct. I mean, the Premier, in his letter of 28th April to me, and he cited Article 73 in this context, And he said that in the process, this would gradually transfer power from the UK and the government's group back to the Virgin Islands people. And I think that word gradual is important. The difficulty with this piece of legislation is that it would involve a whole-scale transfer of power, and therefore needs to, I think, to be thought about very carefully. And we should be subject of greater debate and consultation than was possible for the legislation which is adopted by the House of Assembly. So I do not rule this out for the future, but I think it needs to be very carefully considered. And I think that, frankly, there needs to be greater capacity building before that transfer would be wise, but I recognise there will be differing views for discussion on the issue.
Just elaborate on what do you mean by greater capacity building?
At the moment, if we were hit again, and I hope we are never not, by an Irma-type hurricane, I believe that that would need to further engage the governor's responsibility under Section 60 for security and external assistance, and beyond the areas of external assistance which are already devolved to the government under the Constitution. And after Hurricane Irma, the governor had to play a very strong leadership role in that response, and had to see with the Director of Disaster Management. And my judgment is that at the moment that position continues to apply. And I say that whilst I also maintain my commitment to a partnership approach, because it has to be a partnership approach. Governor can't do this alone. It has to be working together, but that doesn't mean this complete transfer of power which seems to be proposed.
You mentioned earlier that having spoken to senior or to others with an interest in disaster management, their view was that the disaster management department should sit under the governor's group. Who were these others that you've spoken to?
If you forgive me, I think it's best if I not name names, but I've spoken to people who, both within disaster management and other government departments, who have key responsibilities. And in my discussions, the view has been that for the time being, they would prefer the responsibility to continue to lie with the governor.
And is the sort of present state of affairs that the department sits under a ministry at the moment, but you still have obligations under the 2003 Act? Is that the position we've reached?
Disaster management team is part of the governor's group, and I retain overall responsibility under the legislation.
I see. So there hasn't in fact been a transfer.
No, the position remains as it was prior to the legislation being passed.
Thank you. Now, in relation to this was one of the, if you pick up your written response, please, Governor.
Please, yeah.
This was one of the criticisms that was you were asked to address, and you have done so. I don't intend to read it out, but before I move on, it's at your page 1. Is there any other matter in that response that you wish to draw the Commissioner's attention to?
I think in paragraph 1.5, my understanding is that it is not contended that I have been in breach of the Constitution in not assenting to the Disaster Management Act. I've not seen any contention to that effect. So I believe there's a policy debate here, but I believe that I have acted, within the Constitution in the position I've taken on that matter. Thank you.
Well, if we move on, the other, the next matter that I want to canvass with you is this, and that is the issue of who chairs cabinet in the absence of a governor. Now, I think before we go through this, let's start off with the Constitution, because if you turn to, I think in the Constitution, it's going to be section 36. Now, section 35 creates the position of governor. 36 creates the position of deputy governor. And section 37(1)(a) provides that during any period when the office of governor is vacant or the governor is absent from the Virgin Islands or is for any other reason unavailable to perform the functions of his or her office, the deputy governor shall, during her Majesty's pleasure, act in the office of governor and shall perform the functions of that office accordingly. Section 38 sets out the functions of a deputy governor, but 39 then says deputy, it's headed deputy to governor, and says whenever the governor has occasion to be absent from the seat of government but not the Virgin Islands, has occasion to be absent from the Virgin Islands for a period which he or she has reason to believe will be of short duration, or is suffering from any illness which he or she has reason to believe will be of short duration, the governor may, acting in his or her discretion by instrument under the public seal, appoint the deputy governor, or if the deputy governor is not available, any other person in the Virgin Islands who is a Virgin Islander to be his or her deputy during such absence or illness in that capacity, and in that capacity to perform on his or her function behalf such of the functions of the office of governors may be specified in that instrument. We then have, if you go through to section 49, sorry, give me a moment. Section 49, you have the question as to who chairs cabinet. And 49(1) states that the governor shall, so far as it practicable, attend and preside at meetings of the cabinet. And then in the absence of the governor, they shall preside at any meeting of the cabinet the premier, or in his or her absence, the deputy premier. So there's no reference in section 49 to a deputy governor. I think there is common ground that if, as the Constitution provides, you have an acting governor, then that person can chair cabinet in the absence of the governor, and that's provided for. We didn't look at it, but it's provided for by section 39, which allows, or we did look at that, but which allows for someone to act in place of the governor. But the situation seems to be, or that we've reached, is that where there isn't a governor present, or where there isn't an acting governor, then it's for the Premier to chair cabinet. And the criticism that is made, not just of yourself, but of previous governors, is that there has been a practice that in the absence of the governor, a deputy should chair. And there has never been, in reality, a situation where the Premier chairs cabinet. Now, just clarify for the Commissioner what your position is on that.
Thank you. Well, first, I welcome the fact that it appears to be accepted unequivocally that where the governor is absent from the territory, that the acting governor can preside over cabinet in accordance with section 49 of the Constitution. And that seems to be accepted unequivocally, and I welcome that. The difficult issue relates to the deputy to the governor under section 39 of the Constitution. And as I understand it, that was the practice, that the deputy to the governor would chair cabinet when the governor was absent for a short period, but on the territory.
I'm sorry to interrupt, Governor. That deals with chairing the cabinet, but over and above that, various things have to happen before a cabinet meeting. I mean, for example, the cabinet secretary, the governor, and the premier, that's the cabinet steering group, set the agenda of the cabinet. If the governor is not available for the reasons we're talking about, so there's no acting governor, does the deputy governor do that?
The issue has not arisen since I've been here as governor, but depending on the interpretation one adopts of the Constitution, then the deputy to the governor could be empowered to do that.
Yes. Okay.
Thank you.
No, thank you.
Thank you. As I understand it, the issue came to a head in May 2020 of last year, when a challenge was made to the practice of allowing the deputies to the governor to chair cabinet when the governor is in the territory, but for one reason or another, unable to chair. And the Governor Jasper, did what he should have done. He sought advice on the subject from the then Attorney General. And the then Attorney General advised on 20th of May that the governor could, by instrument under seal, authorize the deputy to the governor to perform all of his functions, including the chairing of cabinet. So that is the advice which the governor received at the time from the Attorney General and acted on it. There is, of course, I'm aware, subsequent advice from the current Attorney General in her advice to the Premier of 13th January of this year, where the Attorney General takes a different view of the matter in paragraph 12 of that letter, although with respect, I think the current Attorney General's reasoning on that point wasn't made out quite as fully as the reasoning which was set out by former Attorney General Aziz. Now, so that's the situation I face as governor, with those conflicting pieces of advice. I'm also aware of the advice that was given by Foreign Commonwealth Office Legal Counsellor Susan Dixon on this subject in 2008, which I think should be in the bundles.
It is.
Mr. Abbott.
It's at page 881 in bundle 1.
Thank you.
I may have tried to take it too fast, Governor, but so perhaps if we just so that we've got the timeline, if you look at 883 on the 24th, you have a letter on the 24th of April 2007, which is from Dr. Orlando Smith as Chief Minister, and it's as part of the work that was coming up to confirming or finalising what became the 2007 Constitution. And what was agreed, and there's an exchange of letters, one on the 23rd of April from Ian Hendry on behalf of the Foreign Commonwealth Office, which is at page 884, and then one from Dr. Orlando Smith on the 24th of April 2007. And they both agree that the position is that when there is a reference to the governor chairing cabinet, it encompasses the person who acts as governor in absence. What you have is, at 881, you referred to it as an opinion by Susan Dixon, legal counsellor at the Foreign Commonwealth Office in March 2008. And tell me if I've misunderstood this, but in her view, constitutionally, there is nothing to stop a governor appointing a deputy governor to perform all of the functions of a governor.
That's correct.
And that includes the function of chairing cabinet.
That's correct.
But what she does point to is that from the exchange of letters that it was that we've referred to, that it appears to have been the intention of the two governments that where there was no governor or acting governor to preside, then the premier would preside.
That's correct.
So that's I think the position we reach in 2008. You have referred to a legal advice from the Honourable Babar Aziz, the previous Attorney General, and you've produced that advice to the Commissioner. It's in amongst the documents that the Governor has provided, and it's at page 1. And this is a memorandum dated April 2019. And again, tell me if I'm over summarising, but the effect of that was that Babar Aziz's view as Attorney General was that a deputy could chair cabinet.
That's correct.
But as you point out, the current Attorney General has reached a different view. And if I think the opinion from Mr. Aziz was sought by the Deputy Governor. But as you've said, the current Attorney General's view is different, and that is that she makes 2 points. And firstly is that a deputy cannot sit in cabinet, so a deputy governor cannot sit in cabinet. But secondly also, and this relates perhaps to a different issue, but that is that a governor can chair a cabinet remotely.
Yes.
Now that's the position. So in terms of legal advice, but in terms of practicalities and the reality, what is your position in terms of what your understanding of who can chair cabinet in your absence?
Thank you. Well, I mean, first of all, it would. Well, it does require a degree of patience and wisdom to try to read through the different opinions on this matter. The first and I think the most important point, if I may, is that in the papers which have been submitted to the Commission, it is claimed that the previous governor acted in breach of the Constitution in this matter. And I believe that's incorrect. I think the advice of Susan Dixon in 2008, right back at the beginning of this, was accurate. That the Constitution does not preclude a deputy governor from presiding at cabinet meetings. And there is a constitutional and legal basis for the deputy so to preside. So I do not believe that, as has been suggested, that there was any breach of the Constitution in this matter. Secondly, I note that despite the understanding was set out in the exchange of letters between the former Chief Minister and Mr. Hendry, the practice appears to have been, despite that understanding, that the deputies to the governor chair cabinet, and that was a practice which the current governor inherited. In terms of my own position going forward, and in light of the wording of Section 49 of the Constitution, in light of that exchange of letters, I do not preclude circumstances where the Premier would be asked by me to chair cabinet. But I would expect them to be few and far between. First of all, because as governor, I intend, whenever I'm on the territory, to be available to chair cabinet. And secondly, I think that the advice given by the County Attorney General is most helpful in that respect. Her advice was, actually in the COVID-19 context, it would be possible for the governor to chair cabinet remotely. But I think that also, by extension, if I may, would mean that if, for example, the governor were on official business in Virgin Gorda or Anegada, then the wonders of modern technology, which probably were not envisaged in 2007, 2008, would allow for remote chairing in those circumstances. So I don't rule out, in line with that exchange of letters, Mr. Rawat, that there will be circumstances in which the Premier might chair cabinet, but as I say, I would expect those circumstances to be few and far between. I should say also that, I would expect to the Premier, where chairing cabinet, that consult in advance of that to the extent possible. And I think if there were matters pertaining specifically to the governor's responsibilities before cabinet, obviously that consultation would be even more important. I think I would be proposing in those circumstances, if I could not physically attend, that which obviously I could not, the Deputy Governor might be able to attend that part of discussion in Cabinet, but I don't rule out that possibility for the future, Mr. Rawat.
So as I understand your evidence, Governor, but by those means, because there is a difference in legal opinion.
Exactly.
But as I understand your evidence, you don't envisage any insuperable problem with this in the future, because it can be dealt with in one way or another by practical means, remote attendance, the Premier chairing cabinet after consultation, or whatever. That's
correct. I mean, there could be an issue if the governor, touchwood, were seriously ill, and so seriously ill that he or she were not able to even remotely chair cabinet. But subject to my health prevailing commissioner, I hope this situation is not going to arise in practice. In practicalities. That's correct.
If so, I understand that. But if there were, and we've dealt with this, I think, before, but if there were a difference of legal opinion as to what the Constitution meant, which there is here, is there a mechanism for resolving that? I mean, in some constitutions, there's a mechanism whereby a sort of declaratory relief can be sought from some court or another. But is there any mechanism whereby that can be resolved? It may be a question for Sir Geoffrey rather than you, but
I suspect it might ultimately have to be the courts. I would hope to resolve this matter in a way which would not involve
exactly
to dispute. But yeah, there's conflicting legal advice on this. But what I am confident of is I don't think there's been any breach of the Constitution involved in this, and that's my fundamental position.
Because the previous governor was really following the attorney's advice.
That's correct. Yes. Thank you.
Okay. Thank you.
But is it a sort of peculiarity of the Constitution that cannot, under Section 39 now, on the latest advice you've received, you can't by instrument allow your Deputy Governor to perform all of your functions, including Cabinet. But under Section 37, your Deputy Governor automatically acts as the Governor in your absence.
That's correct in terms of the latest advice on the position of Deputy to the Governor. It's a question of whether one prefers the advice given by Ms Dixon and Attorney General Aziz on the one hand, and the latest advice given by the current Attorney General on the other. And there may be differing views on which advice is to be preferred.
But putting a sort of advice aside, but returning to the theme that I've been seeing with you, which is the importance, and you've acknowledged it, of every effort being made to ensure that the BVI is able to act with autonomy and able to have control over its own affairs. Isn't a convention whereby when the governor is absent, the Premier should be the chair, one that should be pursued?
My view is that the Constitution is quite clear that the acting governor exercises for and on behalf of the governor all of the functions of governor. And that's section 2, paragraph 3 of the Constitution, read in conjunction with section 38, paragraph 2. So section 2, paragraph 3 makes clear that reference to the holder of any office shall be construed as including a reference to any person who is for the time being performing the functions of that office. And section 38.2 provides that the governor may authorize the deputy governor to exercise for and on behalf of the governor any or all of the functions of the governor. So the acting governor is the governor, and hence has the power to preside over cabinet in accordance with section 49, paragraph 1. And the exception in section 49, paragraph 2 is when we don't have an acting governor in place, when the Premier may chair.
Right, follow. Thank you.
Thank you. I think that point is clear. I believe that point is accepted by the government, and I welcome that. I think it's been a helpful acceptance of that basic position.
Right, I follow. Thank you.
Thank you.
If I could ask you just to turn to page 825, I want to move on to
825.
yeah.
Thank you.
Although before I do, again, this was a potential criticism that we raised with you, Governor, so which is at your page 3. If there's any other matter that you want to draw the Commissioner's attention to, please do so now.
I suspect that we have discussed that particular issue sufficiently, Mr. Van Wert. Thank you.
I want to just move on to the third criticism, which is in effect that governors have taken an approach that inconsistent really with the proper constitutional position and proper convention, in that they take the view that requests for information from ministries do not need to be carried out through the Premier's office. I'd like to start off by taking you back to your own position statement to the Commissioner, and at page 825 of that, please, if you have it.
Thank you. Yes.
It's paragraph 64 and 65 that I want to draw your attention to, Governor. You say there that the public service contains many dedicated and well-qualified officials, but their confidence appears to have been eroded by perceived attempts to exert undue political influence on their work or create uncertainty over lines of authority. Under section 56 of the Constitution, ministers have direction and control of their department, including directing the implementation of government policy as it relates to that department. But unless otherwise agreed between the governor and the Premier, the department is under the supervision of a permanent secretary who is a public officer. Moreover, the power specified in section 56 is without prejudice to the governor's responsibility under section 60 of the Constitution for the terms and conditions of the public service, the role of the Public Service Commission in the making of public appointments, and the ultimate responsibility of the governor for the disciplinary control of public officers and or their removal from office. Such powers vest and should continue to vest in the governor, not ministers. You continue, confidence of the public service also risks being eroded by attempts to limit interaction by the governor's office with ministries, e.g. by insisting that all such contact be carried out through the Premier's office. Such attempts run contrary to section 56(7) of the Constitution, whereby the governor acting in his or her own discretion may at any time request from a minister any official papers or seek any official information. subject to informing the Premier of any such request. They also cut across section 68 of the Constitution, which allows the governor to direct others, not just ministers, in the exercise of their functions, where they involve or affect any matter for which the governor has special responsibility under section 61 of the Constitution. Now, if you then, Governor, turn up, please, page 917 in the same bundle. Paragraphs 55, to begin with, this is the response or the reply of the elected ministers to your position statement. And the reply points to the 2 paragraphs I've just read and continues. The governor asserts without particulars that confidence in the public sector has been eroded because political ministers have made, quote, perceived attempts, end quote, to exert undue interference on the work of public officers and created uncertainty.
Yes, undue political interference.
Yes, I'm sorry, I'll read that again. To exert undue political interference on the work of public officers and created uncertainty over lines of authority, inter alia, by insisting that interaction by the governor's office with their ministries should be carried out through the Premier's office. This is a highly lopsided perspective and illustrates the problem to which we previously averted in the position statement. At 58, it continues. I'll read 50, what 56 does is draw attention to section 56 of the Constitution. Then at paragraph 57, the response continues. A minister therefore has both a legitimate interest in and a right to be consulted on the suitability and performance of senior public officers in his ministry or department. He's entitled to express his opinion both to his permanent secretary and to the deputy governor on such matters. This is not to be construed as undue political interference, but it does require good leadership of the public service to manage possible tensions together with modern systems of training and management. The ministers fully accept that the governor, pursuant to section 56(7) of the Constitution, has the right to request official papers, quote, from a minister, end quote, or seek from him any official information or advice available to that minister with respect to a matter for which that minister is responsible. It is, or should be, a normal and basic courtesy to the minister, however, to address such a request to him or his private office so that he's aware of the request. Furthermore, it is a legal condition of the governor's request that he should inform the Premier of it. It has been the experience of ministers that neither the courtesy nor the duty has always been observed, and that direct contact has been made by the governor's office, sometimes with quite junior officials, to demand information or action of which the minister and Premier are unaware. In addition, the governor suggests that ministers' insistence that his office should interact with ministries through the Premier's office cuts across his power, pursuant to section 60 of the Constitution, to direct any person or authority in the exercise of a function where he determines that function, quote, would involve or affect, end quote, any matter for which the governor is responsible under section 61. However, that power may only be exercised after consultation with the Premier. Once again, it has been the experience of ministers that the governor's office has issued directions to officials in the ministries and departments without observing that direction. So the point is a mixed one, because it goes to a lack of courtesy and respect for the position of ministers and indeed the Premier, because your office essentially, and the governor's office, shall we say, goes direct to sometimes even junior officials. It reflects a failure to really understand the Constitution, because and the role that ministers play in administering their departments. And it again goes to the point that the governor, as the representative of the UK FCDO, can and does interfere in the workings of ministerial departments when there is no need to do so. Now, I know it's a bit of a compendious point, but could you just deal with that firstly by just explaining what you meant when you referred to undue political interference?
I think that there's a challenge over the meaning of the word control in section 56 of the Constitution. It's absolutely correct that elected ministers should set policy. That's what they've been elected to do, and in matters which are devolved to the BVI government under the Constitution, it's entirely for the elected government to set that policy and direction. And clearly, ministers will wish to speak to their senior officials and permanent secretaries to ensure that they have clear directions as regards that policy. But there should be limits to the extent to which ministers can properly direct or control officials as to the advice they give back to ministers and the amount that they might control how they act under their relevant legal obligations. And I'm not going to go into details, Mr. Howard. I believe there have been occasions where pressures may have been placed on public officials which would have stepped over what I would think to be the appropriate mark in that area.
Well, deal, please, then with the second aspect of the evidence that arises from your position statement, which is that attempts to limit interaction with ministers by insisting all contact be carried through the Premier's office.
Yes, thank you. Well, first of all, let me say that on the wider point, I of course recognise that the Governor should be keeping the Premier and his or her ministers informed of matters that the Governor is engaging on with his departments. And I'm not aware of any significant issue since I've been here as Governor where that has not been the case. But I'm afraid that there have been attempts, in my view, to go beyond what the Constitution provides in terms of the Governor exercising his powers. So both in terms of correspondence from the Premier to my predecessor, and then since I've been here, there has been a proposal which would require the Governor's office only to engage through the Premier's office, and that engagement with individual ministers would have to be through the Premier's office. And indeed, I have forwarded to the Commission a draft cabinet paper which would provide precisely for that. And that, with respect, runs contrary to the Constitution, because Section 56, paragraph 7 provides expressly that the Governor, acting in his or her discretion, may at any time request from a minister any official papers or seek any official information or advice available to that minister with respect to a matter for which that minister is responsible. So that's a power of the Governor under the Constitution, and shall inform the Premier of any such request. So there is an obligation to inform the Premier of that request, but the obligation is not to go through the Premier's office in making that request. So the request can be made directly to the ministers concerned. Secondly, such an approach would rather cut across Section 60, paragraph 8 of the Constitution, which provides that the Governor may, after consultation with the Premier, direct others, not just ministers, so it could include officials, in the exercise of their functions where they involve or affect his special responsibilities under Section 60, paragraph 1. So the Governor, under the Constitution, has the right to go directly to ministers, provided he informs the Premier that he is doing so, and after consultation with the Premier, also has the power to direct officials in the exercise of his functions under Section 60. And I've certainly always sought to comply with those requirements, but the proposal that all engagement by the Governor must be go through the Premier would run contrary to those provisions. There's one other practical point here, which is that is clearly right on significant issues that the governor should seek to work in consultation with the Premier, and the Premier hopefully should seek to consultation with the governor as well. But there are plenty of day-to-day practical matters on which officials will necessarily engage with each other. To give you the current example of the COVID-19 response, the support that the UK government is giving to BVI in terms, and has given in terms of provision of personal protective equipment, of ventilators, of test kits, and now 36,000 vaccines, has been done in full consultation with the Premier and indeed with the Minister for Health. But the practical logistics for that, which are rather detailed in terms of working out what precisely needs to be supplied, how it's going to be transported, when it's going to be transported, how best it can be stored safely so that vaccines can be used properly, actually requires a lot of expert-to-expert discussion between my team, the Governor's Office, and health officials, and indeed between Public Health England and health officials here. And it would be simply impractical if it were argued that all of that needs to be done on every occasion through the Premier's office, the Minister's office. It's simply impractical in the interest of the territory. But I do accept that as Governor, I should seek to inform ministers of what I'm doing on matters which affect their responsibilities and inform the Premier as necessary.
But looking at the draft paper that you provided, the rationale is to revert back to what might be described as the status quo, because what's said is that the original approach was that a Governor's office would liaise through the Chief Minister's office with ministers.
With respect, I'm informed that has never been the status quo.
So just clarify what you base that piece of evidence on.
My understanding of speaking to public officials here is that governors since the 2007 constitution have regularly engaged with individual ministries as well as just through the Premier's office.
And your position is that you are entitled to do that under the constitution?
That's correct, yes. And that is with no disrespect to the Honourable Premier. I will always seek to keep him informed on these important vital issues as I believe I do. But I don't think the constitution requires me to always go through him when I'm engaging with ministers. And indeed, in fact, the ministers contact me, not every day of the week, but various ministers will contact me direct to ask me questions or raise an issue with me, and that's not done through the Premier's office either. But I don't think in either case it's involving major issues of which the Premier should rightly be aware as the elected head of government working with the Governor.
Again, returning back to where the balance lies, if it is the, you have, yes, significant but detailed and specific responsibilities under the Constitution, and particularly your Section 60 responsibilities, but everything arguably that falls outside Section 60 falls on the elected government. And surely if the elected government considers that in terms of delivering its services to those people who elected it, in terms of effective government and good governance, that this is an approach that should be adopted, that your interaction as the Governor with various ministries should be with the Premier's office, which has been described to the Commissioner as the coordinating ministry. Surely, irrespective of what the Constitution says, and having regard, as you have said you do, to the need to promote a route and develop self-governance, surely it's incumbent on any governor to go along with it.
I think it's a matter for judgment and perhaps legitimate different opinions as to whether having everything centralised through the Premier's office is or is not the best way of moving forward governance in the territory. But I, as governor, need to speak to the responsible minister who, under the relevant legislation, for example, may have the decision-making power. And particularly when one needs to move speedily on a matter, then going direct to the relevant minister seems to me to be the preferred approach, while keeping the Premier informed. Of course, the Premier can speak to his ministers if he or she so wishes.
And in terms of how the Governor's Office communicates with the BVI public, how is that, or what proposals have been made in relation to how that's dealt with?
In terms of communication with the public, I, of course, occasionally make speeches or issue statements, and I and my team in the Governor's Office are involved in numerous events on the island in support of charitable organisations or in support of other activities in the territory. So, at the moment we're engaged on COVID matters. We're engaged on organising the external security review of the prison, which falls under my and NSC responsibilities and my official work in that regard. As regards communication, we have a Facebook page in which we can give details to the public of what we are doing. I think we probably also have an Instagram page, but I confess I'm not as au fait of certain aspects of social media as I should be. But there has been an issue, Mr. Rawat, over the formal dissemination of statements from the Governor and the Governor's Office. And this is in relation to, again, correspondence with my predecessor, and in relation to a paper which has been proposed to Cabinet, which would restrict the work of the Government Information Service in relation to the Governor's Office, and provide that the Government Information Service wouldn't regularly or automatically improve communication to the Governor's Office, but they would be decided on a case-by-case basis in consultation with the Premier. And it's claimed in the paper that again, it is in line with past practice. And again, my understanding is that is not the case. The Government Information Service has always hitherto issued statements from the Governor's Office, from the Governor, because it is a Government Information Service and the Governor is part of government. And so GIS has always done this in the past. Now, I hasten to add, and I should rightly add, that both in relation to the paper on communication only through the Premier's Office and the paper in relation to limiting the role that the Government Information Services would play, I should say that neither of those papers has been brought to decision in Cabinet. And I have sought to find a practical way forward on this issue with the current Premier, and I will continue to do so. But I would be very concerned if either of those papers were to come to a decision, because that'd be the first would be contrary to the Constitution, and the second would be contrary to what a Government Information Service should provide. But for the main part, we've been able to provide a practical way forward, and I hope that will continue.
You said that in relation to the point you made about the Government Information Service, that what's been communicated to you as the purpose of the Government Information Service is not, or what's communicated in this draft paper doesn't accord with what you've been told by others.
Oh, of the past practice, that's correct.
Yeah, and in terms of that, those others, is that people who have worked in public service?
Yes, it is.
One point that I noticed made is that it should not be part of the Government Information Service's role to promote the UK government or the FCDO.
Correct.
So from the perspective of the governor having a role in government, what is its job in terms of putting out material from the governor's office?
Well, there's a degree of judgment required here. If the FCO government policy is to supply each of the overseas territories free of charge all the vaccinations that the territories need in COVID-19 response, that is a UK government policy. What is clearly directly relevant to BVI. In my view, in those circumstances, it would be appropriate for the Government Information Service to publish that information. If, on the other hand, we're talking about, let's say, a wider government, UK government statement, let's say in relation to Brexit or international arms control negotiations, which, well, actually Brexit does have relevance to BVI, but let's say international arms controls negotiations which don't have an obvious direct effect, then I recognise there that government information services may not see that as particularly pertinent to their work. So the degree of judgment involved here. But what I frankly would find difficult would be a view that, on a case-by-case basis, it is for the Premier to decide what GIS should issue. Now, say in fairness, I think we are finding a way forward on this, but I think there's distinction to be made, roughly, slightly imprecise area, which I outlined to you, Mr. Rawat.
What I note from the draft paper was that what the Premier had requested of the Governor, this is the predecessor, was to receive communications from the Governor's Office and the FCDO prior to such being issued to the public. What the point that is made is the Premier, as leader of this overseas territory, must be aware beforehand and not learn of information from the public domain. Is that something that might be suggested, Commissioner, is an eminently sensible proposal, isn't it?
I would always seek to inform the Premier of, well, let me rephrase that if I may, please. In most circumstances, I would seek to inform the Premier of announcements before they were made, which were of a significant nature. But if, for example, I am asking GIS to put out an announcement of the support I gave last weekend to the Lions Club of the British, of Tortola, and support to the BVI national culinary team, who are going to go to a Caribbean culinary competition in Florida in the summer, I don't think that's a point which I would judge it was necessary for me to inform the Premier of. Although, in fact, I did so in the discussion this morning, but I don't think that was necessary for me to do so.
Does the communication work both ways? Is the Governor's Office made aware in advance of communications that the Premier may make to the public, either as Premier or Minister of Finance?
On occasion, but I wouldn't say on a regular basis.
If you could turn up page 918, please. I want to just take you to another part of the response of the, this is the response of the elected government to your position paper on governance. And it points to paragraph 62, two examples of which, if the Commissioner accepts the evidence, would qualify, I'd suggest to you, as particularly significant examples of FCDO overreach. The first, I'm going to paraphrase, but the first is the Blue Belt Programme. And to summarize it, that this was a programme, voluntary programme, in which UK overseas territories would seek support for marine protection and sustainable management of the marine environment. That was launched in 2016. No agreement was reached in terms of the Virgin Islands joining that programme, and they did not do so. But it notes that at paragraph 64, what the FCDO did on the 3rd of April 2021 was to issue a press release announcing the world's first network of underwater camera rigs is being rolled out across the British overseas territories, including the Virgin Islands, as part of the UK government Blue Belt programme. And a statement was issued on Twitter that the Virgin Islands will be part of the Blue Belt programme. And what's noted is that despite correction by the Department of Agriculture and Fisheries, neither the press release nor the governor's tweet has been withdrawn or amended. Now, I think that, I'm not sure whether that's a reference to, yes, it is the governor who issued a statement. So it's the governor tweeting. It then goes on to give the second example, which is that the Virgin Islands' participation in the International Convention for the Conservation of Atlantic Tuna. And in 1998, following the European Community and now the EU's accession to that convention, the UK became part of the EU's delegation, and the Virgin Islands with other territories formed a separate delegation. Those territories had therefore a separate catch limit for albacore tuna up to a threshold of 200 tonnes per annum, which they could then allocate amongst themselves. The effect of the UK's withdrawal from the European Union, however, was that they ended up with one delegation, not two. Both the UK and the OTs allocated one single catch limit, and this time it was of 434 tonnes. And the effect, again summarising, was that there was a change in the quota of tuna that the Virgin Islands could catch, with DEFRA proposing to the Department of Agriculture and Fisheries here an allocation of 10 tonnes as the catch limit for the Virgin Islands. What's noted in the response is that no agreement on that was reached. And then it continues, even although discussions on the division of the quota were not completed, on 28th June 2021, the Governor's Office wrote to officials at the Virgin Islands Department of Agriculture and Fisheries stating, quote, "If we do not hear from yourselves by the 30th of June, I will inform DEFRA that the proposed allocation of 10 tonnes is acceptable." And what's pointed out is that such a statement by the Governor's Office is inconsistent with section 56(5) of the Constitution. We can look at that if you need to. It notes that fishing policies for the Minister and the Cabinet to decide, and therefore it was not for you as Governor to agree to the allocation. And you shouldn't have made a communication to officials. So it takes us back to the points we were looking at earlier, without informing the Minister or the Premier or raising the issue in Cabinet. And the point that's made, and again, it takes that to a point I've put to you already, Governor, which is, UK government's priorities triumph over Virgin Island government's priorities. And this is an example of that, because what the point that is made is that whilst the UK government may consider that its allocation, so 10 tonnes to the Virgin Islands, to be a fair assessment, doing that in a unilateral fashion is inconsistent with a partnership based on consultation and mutual understanding. And it connotes, again, back to, I think, the point that I've made again, a lack of respect for the Virgin Islands, and particularly so because the Commissioner has heard evidence about the importance that is placed on the fishing industry, and has heard evidence about efforts that are intended to expand and promote the fishing sector, not least from the perspective of food security. So if taking those in turn, firstly, and there's a number of themes I'm trying to explore with you, but the Blue Belt programme, first of all, you have a situation where the Virgin Islands doesn't sign up to it, and yet press releases from the FCDO, from the Governor's Office, are saying that they do.
Thanks, Mr. Howard. Well, on the first point in relation to the underwater camera rigs, and these are underwater cameras designed to, as I understand it, track fish movements. and help actually both fishing and conservation in this area. It is correct that when that announcement was made, that BVI at ministerial level had not at that point agreed to it. And therefore, I think it's unfortunate that the press release was issued by the FCDO. It wasn't done deliberately to overcome BVI views, but it should not have issued in that way at the time. It was an oversight. And I made clear my regret for that oversight. But there were official discussions going on in relation to underwater cameras, but they've not got ministerial sign-off. So there's criticism to be made in that area. I accept that. I accept that criticism.
And who did you make your regret clear to?
I made my regret clear to the Minister for Natural Resources, and I believe in Cabinet as a whole, because it was raised. I made my regret clear on that. So, you know, I accept the point. I accept the point there. I think it's the only such example that's been given. As regards the International Convention for the Conservation of
Before you go on, what is the current position in relation to the Blue Belt Programme?
My understanding, I mean, I've further information has been provided to the government, but my understanding is that as yet, the BVI government has not chosen to accept these underwater cameras, which will be provided from the UK for use. And actually, they would be owned by the BVI government, but for the time being, the government decided not to accept them, which is their choice.
And so your evidence on this is that the FCDO issuing a press release, and indeed the governor, that's you, issuing a statement on Twitter, were just matters of oversight. It was premature.
It was premature. It should have been checked before it came out. I accept that.
Okay, well, could you deal with the albacore tuna point, please?
Yes, thank you. As best I can, because I would not claim expertise in this area. But it is correct that prior to Brexit, there was a separate small harvesters threshold, which was available to the overseas territories as a whole, with a threshold of up to 200 tonnes per annum, which could be allocated amongst the overseas territories. But that has changed because of Brexit, and we now have metropolitan UK, including Scotland, Wales, Northern Ireland, and England, and the overseas territories, and I think the Crown dependencies, as a single entity under the convention. And so the UK receives a single UK pot, as opposed to what was previously a divided pot. And the UK is responsible for determining the division of that pot. And so the aim of the Department for Environmental, Food and Rural Affairs, DEFRA, in the UK, is to provide the overseas territories and the different jurisdictions in the UK with sufficient quantities of albacore quota this year, based on the historic activity in this fishery and based on their specific needs and capacities to use those quotas. And because there's a limited amount, not everybody may be able to get all that they would wish. And the proposal that was made to the Virgin Islands was an allocation of 10 tonnes of albacore tuna as the catch limit. And the belief, based on all the evidence available to DEFRA, was that would be more than adequate to meet any likely need in BVI. Indeed, BVI has reported 0 tons of northern albacore catches in recent years. So either BVI has not reported correctly its catch, or there's very limited demand for albacore tuna. And the belief of DEFRA is that an initial amount of 10 tons will greatly exceed recent catches. If, of course, that catch should rise in future years, then the possibility of a higher allocation applies. So that was a proposal that was put to the territory here. No agreement was reached, no response was being received in relation to that. And so ultimately, Mr. Eason in my office had to say, if we don't hear from you, we'll assume it's acceptable. That was a position that we reached. And of course, ultimately the consequence, sorry, the reason this has arisen is because it is for the UK for ensuring compliance with the relevant international convention. We have to work within the allocations that we've been given. And so we have to make sure that the allocations which are given to the different jurisdictions of the UK and the different overseas territories do not exceed our quota. Hence, there's a need to give a realistic limit. But my belief is that the allocation proposed of 10 tonnes is more than adequate to meet any likely need in the BVI for the coming year.
I mean, Commissioner, I think it might be going on for a bit, and I think Mr. Kasdan could probably do with a break. So,
shall I try? Governor, we have to have breaks, as you've probably seen, for the stenographer after about an hour. We've been going a very good hour. So we'll break now for 5 minutes.
Thank you, Commissioner.
Yes, Mr. Rawat.
Thank you. Governor, I'd like to now turn to another criticism, and I think probably the best way of dealing with that is, at least initially, to just summarize what the criticism is. Indeed, set it all out, and it goes to the fact that the responsibility that a governor holds for the public service, and it's this: the governor is constitutionally responsible for public service reform, but has neglected this responsibility. For example, one, there is a lack of human resource systems and infrastructure in place to allow policy development. Two, the current pay structures are a significant cause of problems in recruiting to the public service. And three, record keeping is a matter for the governor and is in a parlous state. Four, no proposal for the desperately needed transformation of the public service was forthcoming from successive governors and deputy governors until late 2017. Now, that's the context, but just to take us back to the Constitution, this is one of your responsibilities under Section 60, is it not?
Certain aspects of the public service are my responsibility under Section 60. Yes, that's correct.
I mean, that's fair enough. I mean, what it says is the terms and conditions of service of persons holding or acting in public offices without prejudice to Section 92. And Section 92 takes us to the role of the Public Service Commission in appointing or providing advice to you as governor when appointing public officers. Now, you say in your position statement, and this is at page 825 in the bundle. 825, please.
Thank you.
Taking us back to paragraph 64, but you explain there that the public service contains many dedicated and well-qualified officials, and that they fall within your responsibility. So please, first of all, outline what you understand to be the responsibility of a governor under the 2007 Constitution for the public service.
Thank you. Well, strictly read, Mr. Rawat, the position is as set out in Section 60, paragraph 1, on the terms and conditions of the service of persons holding or acting in public office, and then the appointments following the recommendations of the Public Service Commission. So that's what the Constitution says, and then we have the provisions on the respective powers of ministers and permanent secretaries in relation to the direction, control and supervision of their departments.
Are you referring to Section 56?
That's correct, yeah. But beyond that, the view has been that the governor, the deputy governor's office in particular, has been seen as responsible for the overall management of the public service, and I certainly do not want to disassociate myself with that view of the function of the deputy governor's office. They played a key coordinating role in the management of the public service, and there are certain bits of the public service which fall directly under what's called the governor's group, from human resources to citizenship and passport issues, and then of course liaison with the different independent institutions under the Constitution, which will be coordinated through HR, for example, within the governor's group. So all of those responsibilities I fully accept, and in that respect, I think that some of the correspondence I've seen that the sole responsibilities in relation to terms and conditions of service doesn't reflect the full picture. But that doesn't mean that sole responsibility for the public service rests with the governor and the deputy governor, and that's for two reasons. One is because the budget for the public service comes from the Ministry of Finance and the elected government and the budget which is approved. So all the budget for pay and training and offices and equipment, subject to what may be provided by the Governor's Office through our individual programmes, that budget comes from the elected government. And secondly, of course, the direction and control departments comes from ministers under Section 56. So in terms of responsibility for public service, I fully accept my responsibilities there, but they need to be exercised in a way which is coordinated with the government's responsibility for providing adequate budget for facilities, equipment, pay and training of the public service. So it needs to be a modern shared partnership.
If I asked you just to turn up 119, please. In the bigger bundle. In the bigger bundle. Okay. It's still in bundle 1.
119. Thank you. Thank you. I might, if I may, come back to the point you made, Mr. Arawat, about no proposal. I think you said on public service transformation since 2017.
Yeah, I'll give you
I'd be grateful.
An opportunity to deal with that, Governor. But if I could just, I just want to give you some context to the question that I'm going to ask you, because I'm taking you back to the position statement from the elected ministers. And if I draw your attention to paragraph 48, it begins by referring to the difference between the 1976 Constitution and the 2007 order, because it makes the point that responsibility for policy formulation in all but reserved matters was conferred on the newly created cabinet. And then says, yet as the PAI report shows, no corresponding human resource systems and infrastructure were put in place to make that task an effective reality, despite the growing complexity and volume of the government's responsibilities. Now, the PAI report we will find at page 242 in the same bundle. Can I, before returning back to paragraph 48, ask you just about that? Is that a report of which you were aware?
Yes, indeed. Not only am I aware of it, but that report, and this is simply part of, I believe, a larger report, was actually commissioned and paid for by my office. So it was a governor's office who paid for this consultant to come and identify where there were weaknesses and challenges in the public service and make recommendations on how they might be addressed. So that was commissioned as part of my responsibilities towards the public service.
Now, it's given a project number there, which ends in 2018. So was that when it was commissioned, PAI were commissioned to do the work?
I think so, Mr. Rawat. I cannot swear to it, but I think that's likely.
And you say it's part of a larger report. What was the larger report?
Well, the PAI consultants worked on various different aspects of governance within the territory and the public service. And this is the one which has been brought before the Commission. I
see. So it was commissioned by the Governor's Office in the BVI to work on various aspects of the public service. Did it produce one single report or a number of reports?
I think I'm correct in saying a number of different reports, Mr. Rawat, but again, I will need to go and check that point. Thank you.
And was it, were those reports then shared with the Premier's office or with other ministries?
They've been shared as appropriate with others, yes.
Thank you. But at the behest of the Governor's office?
Quite a lot of this is before my time, Mr. Rawat. I believe so, but I would need to go back and look at the papers in order to be able to be absolutely confirmed that. I don't want to mislead you with something I cannot, without checking myself, confirm.
But nonetheless, if we go back to paragraph 48, I mean, it's used by the elected ministers to show that essentially a lack of resources, I've pointed out. And if you go over to 49, what the point is then made that you have a void in policy development, planning and coordination, which there is no doubt a strong temptation on the part of the Governor's Office and the FCDO to fill by means that can appear to be coercive. That in turn leads to further tension and distrust and the debilitating effects on the public service of which mention has been made. If you look in the same document at paragraph 132, the point is made there that in the Virgin Islands, the programme to design and introduce a modern framework for the public service only commenced in October 2017. When in the immediate aftermath of the hurricanes, the Cabinet was asked to approve the launch of the, and this is the Public Sector Transformation Plan, proposed by the Deputy Governor and the Director of Human Resources. And the FCDO gave financial support for the recruitment of an external consultant to help with its design. That must be a reference to PAI.
That's correct, yes.
It appears that the Deputy Governor has received little additional FCDO assistance in the implementation of reform, yet these are matters, the effectiveness, capacity and management of the public service, for which the constitutional responsibility and right of initiative lie exclusively with the Governor and ultimately with the UK government. Just again, I'd like to just ask you just to turn up page 144, please. This is the supplementary note that was submitted on behalf of the elected ministers, and at paragraph 26, it points yet again to a central problem with good governance in the Virgin Islands, which is the condition and chronic neglect of the public service and of its critical policy development functions. For that neglect, successive governments and the UK government, which promised support for the public service it does not appear to have delivered, cannot be exempt from criticism. So I've tried just in summary to set out some of the points that are made in support of an argument, which is that there has been chronic neglect and chronic over years, with the effect that it undermines the ability of the elected government to function, because it means that policy formulation is delayed, it's inadequate, it's insufficient for the elected officials' needs, and the consequences government cannot move with the speed that an elected administration may want to move with, and they may not be able to achieve the outcomes that they wish to achieve. Now, I'll give you an opportunity to respond to all of that, but can we start with the general orders? Now, these govern, these are the terms and conditions of civil servants, are they not?
Yes, yeah.
The information that's available to the Commissioner is that they've not been updated since 1982. Is that right?
I believe there's not been a comprehensive update since then. You'll be aware that there are current efforts to have a new public service management code, which are sitting with I believe the Attorney General's chambers at the moment. So there's been no comprehensive review since then.
When you say comprehensive, are you suggesting that there has been some updating?
I believe there has been some updating as the public service has changed, but I would need to check the point to confirm it, Mr. Howard.
But the fact that you have that civil public officers are working to a set of orders that were, or at least that have the date 1982 on them, isn't that itself indicative of years of neglect?
I'm not sure it necessarily is, because that code lays down central requirements of integrity and honesty and impartiality. And those are central to any good public service. They're reflected in the code of the public service here, and they should always be reflected in that code. So I think those central tenets remain valid, but that's not to say there can't be some useful updating. But first of all, I recognise there are challenges in the BVI public service. It is perhaps not unheard of for elected ministers to complain about their public service. I've been myself a public servant in the UK for many years, and one sees such things happening. But I don't claim perfection on the part of the BVI public service. There are many fine public servants with whom I've worked, first-class public servants who would match what would be available in the UK and elsewhere. But there are areas which require development. And indeed, the PAI paper, which we referred to, was paid for by my office specifically to help to identify some of those concerns. But to suggest that there's been no attempt at public service transformation until 2017 is inaccurate with respect. And I have submitted to the Commission in my papers a table provided to me by the Deputy Governor's Office, which sets out various initiatives which have been taken since 1999, i.e. before the current constitution, to the present time to develop the public service development programme, which indeed was launched in 1999, HR reform in 2000, the establishment of the Complaints Commission, and looks at maladministration within the public service in 2003. The fiscal management legislation, which was developed in 2013, and then since 2013 also worked on improving service deliverance by the public service. So the current public service transformation paper is a continuum of what has been attempted in the past. Now, if you say to me, has all of this led to a perfect public service? I do not say so. It is a continuous journey, to use that analogy again, to get the best performance that we can. The public service transformation paper itself, it's been a bit held up by what, in my view, has not been entirely fruitful debate. You will see in the correspondence that at one point the Premier took the view that his department should be responsible for public service transformation. And on the other hand, we have current correspondence. He says he should be responsible for this. Another correspondence saying actually all the failures should lie at the door of the Governor's office. The answer, it needs to be a shared approach. And I'm glad to say that my predecessor wrote to the Premier proposing a shared approach in taking forward public service transformation. And that has now been agreed, and the paper will shortly come to Cabinet, which I hope can make further progress, in particular in areas of good governance, including establishing a strategic policy and planning unit within the Premier's office, a digital transformation and e-government, customer service improvement, and improvements in public administration and human resources management. So I hope we're going to make progress in that area, but it is incorrect to suggest that work in this area only started in 2017.
But I'll come back to the public service transformation programme. But just in terms of funding this process, though, you say that it hasn't been, or it's been ongoing since before 2017. But how have whatever efforts have been made to support the public service been funded?
Thank you. Well, the UK government has funded training in various areas for different elements within the public service. The total funding, and this is beyond the Irma response funding and the 13 million to which I referred to earlier, Mr. Arawat, which the British government has spent since 2018, since the start of 2018, on numerous projects within the territory, is 14.28 million pounds, and a projected spend for the end of this financial year of 17.656 million pounds. And not all of that is about public service.
So are those pounds or dollars, Governor?
Sorry, pounds.
Right,
sorry. 14.218 million pounds spent so far since 2018, and the forecast of £17.656 million. Now that's been on various items, some of them, for example, environmental projects, so solar power, tackling stony coral tissue loss disease, providing assistance in maritime law enforcement, but some elements of that money have been specifically related to public service capacity building and training. And although it's difficult to disaggregate these figures and define what is precisely training and what is wider work for the public service, but I estimate specifically related to capacity building and training, a figure of £2.14 million would be attributable to that.
Since what, over what period?
Since the beginning of 2018, with a variety of different programs, but they've involved, for example, public finance management training. They've involved IT information and management kit provision, work on international health regulations, work on child exploitation online protection, work for disaster management capacity building, all elements of public service responsibility. Now, if I may, with respect, contrast that service and support from the UK government with the training budgets for the public service, which have been provided by the BVI government. Since 2016, there has been a steady decline in the budgetary provision for training of the public service. In 2016, $138,000 was provided for local training of the public service, $138,000. And then there was additional money for scholarships. In 2021, the provision in the BVI budget for training of public servants is $25,000. $25,000 for almost 3,000 officials. And with respect, I would suggest that is an inadequate sum. And that is why I say that while I accept my responsibilities for the public service, and I want to do all I can to assist the public service in providing what we all need, and what ministers need and what the public need, it requires more financial investment from the government, as well as whatever assistance the UK can provide.
How many public officers were there in 2016 though?
I suspect it was slightly larger than it is now, because there was a sort of hiring freeze put on and some positions left vacant, but I don't know the precise number, Mr. Rawat, but I suspect it was slightly larger.
Just before we leave the public service transformation, you referred to correspondence from the Premier. If you take the larger bundle and go to page 446.
Certainly.
I think this was what may have been, if I suggest, you were referring to perhaps a delay in progressing the public service transformation plan. And it's a letter dated the 16th of October 2020 from the Honourable Premier to the Governor, then Governor. And I'm going to let you speak to it, but what the point is made is that whilst the human resource functions of the Governor's Group do form part of the public service transformation agenda, the vast majority of the exercise pertains to the reform of the practices, processes and procedures for enhancing the administrative functions within the various ministries, to improve the effectiveness of the delivery of services by the ministries to their clients, the public, in accordance with the national vision. Ministers report to the Premier. The national vision is the remit of the elected government, which is determined and executed by the Premier and his ministers. And the Premier's letter points to, again, the Constitution. And hence any programme for the execution of the government's agenda and the related administration therefore lies clearly with the Premier as the head of the elected government. So as I understand the point that you're making is that the Premier's view was that the Public Service Transformation Plan should sit under his ministry.
That's correct, yes.
And not under the governor's group. And because your role was human resources, not the sort of day-to-day dealing of public service delivery.
That's correct, and specifically terms and conditions of the public service from the earlier correspondence.
So the Premier took a narrower view of Section 60 than perhaps the then governor did. Would that be a fair characterization?
That's correct, yes.
And what he points out in the letter is that there are areas that, based on the current allocation of ministerial responsibilities, there are areas in the public sector transformation plan that are inadvertently listed for execution by the governor's group and which need to be restored under the ministry where they substantially reside. These include matters pertaining to the BVI Tourist Board, which is a portfolio under the Premier's office, the Public Service I programmes, which is a television product established under the Premier's office where GIS is a programme. And he then refers to the Archives and Record Management Act is another area that is inadvertently being referred to as the responsibility of Governor's Group, which ought properly to reside with the government ministries, namely the Premier's office. Archives and Record Management is indelibly linked to the cultural identity of the people of Virgin Islands, which is the essence of the Virgin Islander, encompasses the political advancement, economic empowerment, historical and economic connection to the British Virgin Islands and its people, not the governor's group. But this is not the Premier wanting to take over the transformation plan for takeover's sake, is it? It's the Premier approaching this on the basis that there are functions that more properly sit underneath ministries and not underneath the governor's group. Would you accept that?
Thank you. I think it partly depends on what the public service transformation programme encapsulates, but a broad programme would indeed involve certain responsibilities of ministers as well as responsibilities of the Deputy Governor's Group, which is why I think a shared approach is a sensible way forward.
If we turn it to the smaller bundle to page 180,
the smaller bundle, so 180. Yes, thank you.
One, yes. I just want you to sort of clarify this for the Commissioner, but this is a further letter from the Premier to your predecessor, 19th of November 2020. And this is again on public service transformation. The Premier makes the point that his government and himself are also very much eager to proceed with public service transformation plan. But he refers to the Constitution, which he says is clear on how the responsibilities of government are divided between the governor's group and the elected Virgin Islands government. As such, my position on the administration of the public service transformation plan is not a matter of personal preference, but one of compliance with the Constitution. And he makes the point that we must always strive not to find ourselves setting dangerous precedents through circumventing of the Constitution. What the letter then goes on to say is the Constitution is clear that the remit of the governor is only for matters within the scope of Section 61. With respect to the public service, this is confined to the terms and conditions of service of persons holding or acting in public offices. Section 47.3 clarifies all matters outside of the scope of Section 61 of the remit of the government and outside the responsibility of the governor and governor's group. And then at the bottom, what the Premier's letter addresses is the leadership partnership model proposed by the Deputy Governor, which the Premier says is inconsistent with the written word of the Constitution, but would deeply offend the basis on which the Constitution was framed. Because what's advocated is an arrangement where the Deputy Governor is chair and the Permanent Secretary in the Premier's office is deputy chair. And the Premier makes the point that that is not a leadership partnership, because it is an arrangement that in effect puts the Governor's office in charge of responsibilities that is outside of the Governor's constitutional scope and above the Premier's office, not on an equal footing. So I've summarised it again, but there's a clear distinction drawn by the Premier between what your role in terms of terms and conditions should be as a governor, and other functions of the public service which more properly rest with the elected government. And that then informs his view that if there is a leadership partnership model, it should not be chaired by a representative of the governor's group. So first question is, what is the present state of the leadership partnership model?
The present state leadership partnership model is that the paper which will go to Cabinet, to which I believe the Premier referred in his evidence the other day, so I think I can probably refer to it, is a paper in the joint names of myself and the Premier, and the Deputy Premier and the Permanent Secretary in his office will have shared responsibilities in this area with respect to each other's responsibilities on a day-to-day basis. To go back to the earlier point on terms and conditions of service, if the suggestion is that the governor is solely responsible for what grade an individual is at and what they're paid for their job, then I think that's too narrow an understanding of terms and conditions of service. The governor is responsible within those terms and conditions and codes for ensuring that we have an independent, professional, well-qualified public service with developmental opportunities for public servants, with training for public servants, with good performance pay for public servants and procedures for dealing with those who are not performing so well. But all that requires, in terms of the training and pay and the equipment and IT with which public servants work and need to do their jobs, requires an adequate budget being provided for that. And in the training area, to which I've drawn attention to, I think there's been a real lack there. So we need to work together. And the Deputy Governor, sorry, my predecessor proposed to the Premier that partnership approach. And despite this correspondence that we see here, I hope we have now found a practical way forward, because it's in the interest neither of myself as Governor nor in the interests of government not to move on in this area. So we need to move forward and not to delay further over this sort of argument.
But just to delay you a little bit longer, one view of that correspondence is that the view of the Premier was that you are restricted to dealing with terms and conditions. Your responsibility is the contractual arrangement. It is nothing else. But you're saying that actually the role of the governor is wider than that. It's about producing a professional, independent public service.
Correct, and I need to work in partnership with the elected government to achieve that goal.
But that then takes us back to the point, because if that is what governors are that is the purpose of what governors do, how do you answer the charge that for years the public service has been neglected by governors and neglected by the FCDO and neglected by the UK?
I don't think that's correct. You'll have seen I refer to the programme since 1999, attempting to improve in various areas of work of the public service and what they deliver to the public. And I've given you the figures since 2018, which the UK government has provided in those areas. Now, if the suggestion is there's more that could be done, well, there could always be more that could be done in this area, but it needs to be done by the elected government here, as well as by the governor's office, if we're going to achieve what we hope to achieve. So a modern partnership approach is required. And I think to lay all the failings at the foot of the governor's office is simply not a proper reflection of the position. Let me also make one further point, if I may, that in terms of the ability of ministers to develop policy, first of all, it's the responsibility of ministers to give policy direction under the Constitution, but I recognise you need good public servants to assist them in that respect. And if there have been failings in the public service and improvements can be made, then I'm happy to try to work to address those failings. But any inadequacies which may be considered to apply within the public service do not excuse failures or failures to obey the law in matters which are clearly the responsibility of ministers, and that is the responsibility of ministers rather than the responsibility of the public service.
Just turn up page 913, please, in the larger bundle.
913 in the large bundle, thank you. Sorry, just give me a moment, Mr.
Of course.
Thank you, yes.
Just want to ask if this is part of the response of the elected ministers to your position statement. And at paragraph 24, the point is made that first, the FCDO has consistently pressed the government to reduce the size, growth, operating costs and wages bill of the public service. No doubt because of that pressure, an external recruitment freeze in the public service was proposed to the cabinet by the then governor in 2010, which was implemented until 2012. And a further freeze on external recruitment was proposed to the cabinet by the former governor in a cabinet paper dated 28th May 2018 and subsequently adopted. Annual performance increments have not been paid since 2016-17. I'll come to the paper that your predecessor presented in a moment. But the point is made at 25 that these policies have led to serious difficulties within the public service, and minister consider a different and more balanced approach is necessary. And the point is made that the elected ministers have approved the payment of annual performance increments for the year 2016-17 and 2017-18. Breaking that down a little, firstly, the point that the FCDO has consistently pressed the government in terms of the size of the public service. Because that is, I would suggest to you, a very serious point, Governor, because it is not, it's a clear example, is it not, of FCDO overreach?
I think it's perfectly legitimate for the FCDO to press the government in this area, but the decision lay with government.
But on what basis is it legitimate for a ministry of another government to come to the BVI and say your public service is too big?
Because the FCDO has a responsibility for the good governance of the territory and has a potential contingent liability for the economy of the territory. And if the view was that we had a public service which was larger than was required for the territory, then I think it was legitimate for the FCDO to express that view. The word pressed is a word that's used by the government. I don't know what was happening back in 2010, but I can see nothing to suggest that the FCDO attempted to enforce this on the current government, or the past government.
So your point is that whatever the FCDO said, it would ultimately be the decision of the government of the day.
Well, to some extent that's correct, because it's to some extent it's dependent on the budget which is given by the public service. I
mean, you may not know the circumstances in which this is said to have arisen because you would not have been here, but have you independently come across information that the FCDO consistently pressed the government to reduce the size of the public service?
No, I have not.
Were you aware of the external recruitment freeze proposed in 2010?
Yes, I've seen papers to that effect. This, of course, was a consequence which happened in public services all over the world of the 2008 world economic crisis and the austerity measures which were required. And so there was a hiring freeze put on external recruitment.
If you take up the second bundle, which we haven't looked at yet, but we'll find the paper that is cited there of May 2018.
At page, sir?
Page 1528. This is the memorandum dated the 28th of May 2018.
Thank you.
From the then governor. And it's seeking this decision. I'm just going to read the first one, but decide to cease non-essential external hiring. And then proposes other measures in relation to filling posts within the public service. But it then sets out in detail background information, referring, of course, to March 2010, a paper called Growth in the Public Service, which was precipitated by a rise in expenditure such as personal emoluments and the cost of pensions, and says it was recognized that controlling the growth size and operating costs of the public service was critical importance, and if not addressed, could result in the inability of government to develop the public infrastructure of the territory, pay operational expenses, and eventually pay its employees. During the hiring freeze, there was stability in the cost of personal emoluments. However, the freeze was lifted in 2012 and employment cost declined. In 2017, Cabinet considered the Cabinet paper memo entitled Reintroduction of the External Hiring Freeze, which was followed by Cabinet information paper entitled Public Sector Reform, Cost of Public Service 2009 to 2016. Cost of the public service remains critical following the impact of the hurricanes on the territory's economy. It's therefore recommended that voluntary measures are taken to cease non-essential hiring in the service and to stabilize employment costs to redirect savings to the areas of highest priority and to avoid payless paydays. Now, I can ask your predecessor about this, but just in relation to this, why is it the role of the governor to bring matters like this to Cabinet?
To the extent, first of all, that these issues may affect the day-to-day work of public servants or their pay under the terms and conditions of their contracts. I believe that's responsibility of the Premier, and of course the wider review that the public service falls under the Deputy Governor and Governor in their work. And that has been a view in the matter which I support and would retain. But it's also clear from this paper that it would require the agreement of Cabinet as a whole, because of the number of decisions proposed in it, would require agreement from finance in terms of financial allocations. And that's not untypical, that a paper coming from the Governor's Group would also require agreement from others within Cabinet to certainly be effective policy.
So is your position that ultimately the size of the public service, whether there's a recruitment freeze, whether whatever steps are taken, lies with the elected government?
No, I think the budget available for the public service lies with the elected government. Within that, I think policies in relation to hiring, for example, are ideally decided on a partnership approach. Some hiring decisions will be specifically for the governor alone to make. Others, I think, should be made in consultation with the relevant minister.
Would a permanent secretary be an example of one that should be made in consultation with a relevant minister?
The appointment is ultimately for the governor with the recommendation of the Public Service Commission, but it would be normal for there to be some degree of consultation with the minister on such appointments.
Taking you slightly off tangent, but going back to 56, the two key figures in a ministry are the permanent secretary and the minister. What support is there presently in place for permanent secretaries and other public officers so that they can maintain their independence?
The Civil Service Code, which sets out the criteria by which they should operate. The support which the Deputy Governor can give to them if they have a concern that there is undue or inappropriate influence or interference in their work. And of course, the ability of the Deputy Governor to refer that matter to myself as Governor. So that's the ultimately where the power of protection would lie. But it's quite difficult because I think that under the 2007 Constitution, this is what I've been told by public servants, that division of responsibilities has become somewhat blurred. And that word control under Section 56 has been used in ways which has made it difficult for public servants to know where they stand. Now, Mr. Rawat and Commissioner, if I may say so, I am emphatically need to wait the outcome of your findings and any recommendations you may make, and emphatically I do not wish to prejudge them in any way, but I think there has been a difficulty there for public servants, and I hope we can find a constructive way forward in supporting permanent secretaries in being able to give that independent professional advice and speak truth to power, including no doubt to governors when required.
Taking you back, Governor, to 913, please. Can I just ask you to look at paragraph 26? Now, this is a response to your position statement. What's said at paragraph 26 is no particulars are given as to any occasion on which a request to provide financial support for a serious, credible and coherent plan for transformative change in the public service has been declined by the existing or any previous cabinet. Do you know of any instances where there has been such a refusal?
Well, I do know that there's been an attempt to move forward the public service transformation plan since 2017, and there have clearly been challenges in getting that agreed, but I cannot speak to a period before then. I think there have been serious proposals in how to tackle records management issues which have not been given the funding which they should have been given.
Could you elaborate on that a little more, please?
Sure, because one of the statements that have been made by the government is that records management and records are in a parlous state. And I think there are challenges in records, as indeed there may be in archives, which are now the responsibility of the elected government rather than the governor's group. A distinction has been made between archives and records. But funding requests have been made to address the public records challenge and been put to Cabinet since 2010, but have been pretty consistently refused. So in 2010, a paper was proposed with a plan for enterprise content management and electronic records management in government. The Cabinet noted the recommendations, but said it needed to be put on hold until the financial situation allowed. A draft Cabinet paper was sent in February 2011 to advance with the construction of the Virgin Islands Archive Repository and Record Centre building, but funding was not advanced. Similarly, there was a paper in May 2011 for a Virgin Islands Archives Repository and Records Building architectural design. Funding was not advanced. A computerized records management improvement project was proposed in 2016 to Cabinet, but was not funded. And in 2017 and 2018, there were proposals for, again, for the architectural design for the Archives Repository and Record Centre, and for an Archives Repository building, which were not funded. Now, I recognise the funding concerns, and I recognise that not all money can be provided for every project, but there is an example of where the Deputy Governor's Office has been trying to take forward work in improving records management, which, for one reason or another, the Cabinet of the day has declined to provide.
Just
and again, so that's why we need a partnership approach. It needs to be the Governor's Group, the Deputy Governors and government to provide the money, working together to tackle some of these issues.
You say government to tackle the money. Does it follow that the emphasis should be on the BVI government funding this rather than the UK government funding this?
Well, in fact, the UK government has funded some assistance in this area, and indeed have done so very recently. If you just give me one moment, please. I can refer to this in my paper. So just give me one moment, please, Mr. Rowett. But the capacity building programme, which has just been agreed on 16 September with UK funding to the tune of $147,554, will support, amongst other things, training in IT, which can assist in records management. It's also providing training in other areas in human resources, electoral processes, and support for software development in the DPP's office and the estates programme. So support has been provided in this area, but further support is required.
I mean, the point I'm trying to make is that if the Commissioner accepts the submission that there has been years of neglect, then isn't it incumbent on the UK and on the FCDO to do more? That you know, if you take the point that you're not just there for terms and conditions, but the purpose of the governor's role, behind which stands the FCDO, behind which stands the UK government. That role is to support, develop a public service that's fit for the 21st century. It's not good enough, is it, to say, well, you know, at some point the local government's going to have to front up and put some more money into it. What should be said is, you know, we haven't done enough for many years, and now's the time to actually step in and do more, and do much, much more.
I think there's a balance to be struck here. This is a largely self-governing territory with finance a devolved area, and this is a territory, while it's faced, of course, the challenges of the global economic downturn, of course, the challenge of Hurricane Irma, has an economy which overall has managed to stay within sound ratios. And self-governance means many funding decisions are for the BVI government to make. The UK has stepped in and provided very substantial assistance, as I hope I've demonstrated in my evidence to the Commission, in relation both to Hurricane Irma response and in relation to COVID-19, and I can give you more details on the COVID-19 costs if you wish, as well as the projects and training programs which I've outlined. If your question is, could the UK do more? Yes, more can always be done, but the primary budgetary responsibility lies with the BVI government, I believe.
The other aspect of over which you exercise primary control is the police. Can you, for the Commissioner, just outline the ambit of your responsibility as Governor over the police?
Yes, I'm responsible for appointing the senior ranks within the police service on the recommendation of the Police Service Commission. The Commissioner of Police reports to me, although day-to-day operational policing decisions are for him to make, and for him to make alone. And then the National Security Council, which is covered by Section 57 of the Constitution, receives from the Commissioner of Police regular briefings on matters of internal security, including the police force. And of course, my wider responsibility for security on the territory includes responsibility for tackling crime, tackling organised crime, or any other threat to the security of the territory, working with the Royal Virgin Islands Police Force.
If you turn up, please, Governor, page 916 in the bundle. That's back to bundle 1. If I draw your attention to paragraph 45, this is again returning to the response of the elected ministers to your own position statement. The attention is drawn to what you say there about the challenges facing the Royal Virgin Island Police Force and the DPP in terms of recruitment, vacant slots and training. I'll come back to the DPP in a moment. You quoted the outgoing Commissioner of Police in his 2020 report noted that the Royal Virgin Island Police Force regular allocated budget falls far below the reasonable costs required to maintain the competencies and highly skilled requirements and demands in investigating crime and bringing offenders to justice. The Royal Virgin Island Police Force currently has 67 roles unfilled, approximately 1/5 the total workforce. Funding for vital repairs and maintenance of police vessels is also needed. You then speak to the independence of the DPP and the Commissioner of Police being important strengths in the system of good governance. but that their effective functioning is dependent on adequate financial resources being provided for their work, which decision lies with the Minister of Finance and Cabinet, subject to the extraordinary power of the Governor under Section 103 of the Constitution to order payments out of the Consolidated Fund. And this is the point I want to draw your attention to, because what is said is ministers are unaware of any request by the outgoing Commissioner of Police for additional resources for recruitment that they have declined. Indeed, during the last budgetary discussions, the outgoing Commissioner of Police was specifically asked what sum he needed to finance his the police, and his wishes were followed. So the issue is taken with the suggestion that where funding has been requested for proper expenditure, it has not been refused. But you seem to be saying the opposite. What do you base your position on?
It's to do with the way that the budget and the release of the budget works, Mr. Rawat. So the budget is allocated to the police force, and that budget may be sufficient to cover the complement of total slots which should exist within the police force. But when a slot becomes vacant because someone retires or resigns, it is not under the current arrangements within the power of the police commissioner himself to go ahead and advertise that slot and have funds released to him to pay for that slot. My understanding, and I'm, I think, well advised on this, is that permission to go ahead and advertise those slots and have the money released for those slots lies with the Ministry of Finance. A similar issue is seen in Governor Jasper's letter to the Premier of 27th July 2020, identifying vacancies not just in the police but in the magistracy and the Attorney General's chambers. And the Governor there had to write to the Premier, noting that the ability to go out and recruit for the gaps which are existing was being held up by the Ministry of Finance, by them not giving the requisite permissions. So, in answer to your question, the budget is in theory allocated under the budget, but if the relevant head, in this case the police commissioner, wishes to go ahead and fill that slot, then permission is required from the Ministry of Finance. And my understanding is that permission has not always been given. And former Commissioner Matthews has informed me that last September, he went to the Premier and Minister of Finance colleagues to discuss vacancies. And he was not given permission to recruit all the specialist officers which he required. He was given, he was sanctioned to recruit a small number of regulars and auxiliaries. So the current system does not in effect give the police commissioner independence over that use of that budget to fill slots.
I mean, Governor, we've heard evidence from other public officers in relation to this, and I think this is what others have said. I think you've said it too. This is just to confirm what you've said. You get the allocated budget, and it's there. In a sense, it's paper money, but you've got that budget. But if you lose somebody for any reason and have to get that place filled, you have to go back to the Ministry of Finance and as it were, get the money again under a different process. And it's that, I think, rather. I mean, everybody always wants more people. anyway in the budget. But it's that's the real issue, I think, according to the Commissioner of Police, who's given evidence, but also other public officers who are in the same position and are understaffed. They haven't got a full complement. And as I understand it, it's not because they haven't got the budget, it's because they can't go out and get the people when they need it.
I think that's an accurate description, Commissioner. My understanding of this is developed in the 10 months that I've been here as governor, and I sort of thought at first, well, the budget's there, but it's not quite the reality of how it operates. And I think, again, that's something which certainly I as governor moving forward will want to see if we can find a solution through that. I mean, as it happens, what is happening is that the UK government has stepped in to provide some additional officers for the police commissioner.
So when did the UK government step in?
Has done it within the past calendar year, and so we have helped to pay for some specialist officers for inquiries which the police commissioner is undertaking, and we've also provided funds in relation to maritime capacity funding to improve the marine base and get some of the vessels back in the water so the police can come onto the waters better. So the UK government has provided funds for that purpose. $530,000 in the last financial year and this financial year to date on additional police and investigative support.
The point that is made, however, by the elected ministers is that the issue is wider than this. And if you look at their paragraph 48, what's said is that there is a long-standing issue of recruitment in the police force for many years. So that's not because of a lack of willingness to allocate the necessary public expenditure. What the response says is they reside in established pay structures not keeping up with need and expectation, low morale, a damaged reputation, and a lack of candidates wishing to take up the role. There has also been a lack of succession planning for retirements and inevitable departures. These matters lie under the superintendence of the governor. If money was the sole solution, successive governors have had available to them the power under Section 103 of the Constitution to direct the expenditure needed. Park 103 for a moment. What the elected minister's response go to is a much more systemic issue, which is that the organisation of the Royal Virgin Islands Police Force is something which is out of their hands, but the way it has been managed again for year after year after year has actually created the organisation that exists today, which is one where you have recruitment issues, where you have low morale, where you have, as they say, a damaged reputation. And that lies at the feet of the governor.
Some responsibilities, of course, may lie with the governor and the police commissioner, but it's not a description which I recognise of the police service as a whole, police force as a whole, who I believe have done some tremendous work since I've been here, particularly in terms of crime investigation, from the arrest of those responsible for murders to drugs seizures, all of which point to some of the very good things the police do. I think that some of the problems do also go back to that budgetary point. So I understand from the police commissioner, for example, that as well as the problem of getting permission to fill positions, when somebody is promoted, say from a constable to a sergeant, the additional money for that promotion also needs to be referred back to the Ministry of Finance for filling. And if there's underpayment in that area, and I believe there is underpayment in that area, that obviously can cause low morale as well. So again, there's some shared responsibility involved in addressing those issues, but I don't accept that overall description of the current police force from all of my experience with it. There are clearly challenges within the police force, and there have been examples of corruption which both the immediate past police commissioner and the current commissioner have dealt with my full support, but there are many fine police officers who have good morale.
But that leads to the next question, doesn't it, Governor? Because if there are significant issues within the ranks of the police, and they're not. If it might be suggested to the Commissioner that he wants to find corruption, abuse of office and other serious dishonesty, he should not be looking towards ministries, but looking towards the Royal Virgin Island Police Force.
And he is. And the Police Commissioner has taken very determined action, both to suspend officers who may have been involved in any wrongdoing, and in referring those cases to the Director of Public Prosecutions for prosecutions to be taken. So the current Police Commissioner has been very firm indeed in that respect, as was his predecessor in the short time as I worked with him.
But by Commissioner, I was referring to this Commissioner.
Oh, I apologise. I'm sorry, it's getting.
The answer is probably still the same.
I'm sorry, Mr. Howard, if I misunderstood the question. It is that point in the afternoon. I apologise.
Yes, but the point is that an organisation that has had reputational issues, an organisation that has recruitment issues, those point to systemic issues that aren't just something that arises over a matter of months, but arise over a matter of years. And being blunt, it all should come back to a governor, isn't it? It's the governor that is responsible for the police, and so it's the governor that should accept that those infrastructural difficulties in the police, and even more, that the demonstrations of criminality amongst the ranks of the police, the finger has to be pointed at the governor's office, doesn't it?
I do accept that, Mr. Rawat. I'm responsible for security in the territory. I take that responsibility very seriously, and I don't shy away from it. And so together with the Police Commissioner, I want to ensure a top-class police force, which is carrying out its responsibilities to the people of the territory. And in that respect, I fully support the action which the Police Commissioner and his immediate predecessor have taken in rooting out any bad apples within the police service. What I am saying is that I don't recognise that characterisation of the police force as being a wholly accurate characterisation. And secondly, I'm saying some of those issues where there have been challenges do relate to matters which are beyond the governor's control, subject to the Section 103 point, because they relate to budgetary related issues, filling of slots and filling of adequate pay, for example, when staff are promoted. So there's a shared responsibility there, but I do not shy away in any way from my overall responsibility for the security of the territory.
We heard from the current Attorney General. The Commissioner has also heard from the Director of Public Prosecutions about the challenges they face.
Yeah.
Those are both constitutional roles. We've spoken about the responsibility you have for the police, the responsibility you have for the public service. To what extent do you have responsibility for the Attorney General and the DPP?
I see they all fall within what's known as the governor's group, and I see, rule of law is fundamental to good governance, and so I see myself as having responsibility for ensuring, to the extent that I can, that they have the resources they need to take forward their jobs. And both the DPP and the Attorney General, as well as the Police Commissioner, have raised with me concerns about their staffing.
And they did hear before me, to Governor. But what's your response to the Section 103 point? And that is that okay, the elected ministers are responsible for money, and you're not. But you have got a trump card in Section 103. What's your response to that?
Well, if I may, Commissioner, just tell you what I have done. And what I have done is to, as you know, there's an overall review of compensation to public service. has been launched, but I, in agreement with the Premier, agreed to a separate accelerated review for compensation for legal and court staff within the government, because I was particularly concerned that this went to rule of law issues. So there's a separate accelerated compensation review taking place.
Was that something that you initiated, Governor?
Yes. Yes, I had representations made to it. I approached the Premier and we agreed on it. So that was very much my initiative. I had a particular concern there. Secondly, where recruitment processes are taking place and the recruitment system needs to go through human resources and then to, for example, the Judicial Legal Services Commission, shall I say, I have tried to hurry along the system while making sure that proper procedures are complied with. But ultimately, Commissioner, if I may, to come to your question, it is correct that ultimately under section 103 of the Constitution, I could order payments out of the consolidated funds, a fund for in order to discharge my responsibilities under section 60 of the Constitution, which could apply to certainly Royal Virgin Islands Police Force, and arguably could apply to, in fact, sorry, not just arguably, could apply to the DPP, for example, in relation to wider rule of law issues related to security. That was a power that was exercised by Governor Duncan in 2017. Henry and Dixon, in their book on the constitutional law of the overseas territories, cite that example. That power exists under the constitutions of Bermuda and BVI. And I think it's also a legislative power within the Turks and Caicos Islands, not a constitutional power. I didn't exercise that power in Bermuda, and I'm not aware that it's been exercised ever by a governor in Bermuda. And I think since 2007 here, it's only been exercised by Governor Duncan. And Henry and Dixon describe it as a power of last resort. I think it is a power of last resort. I do not rule out that I could use it in the future and would use it in the future, but at the moment, as regards the AG's office and the DPP's office, I've taken the action I've described. And as regards the police force, you'll have seen the police commissioner's letter to the Premier of, I think I said in my further written evidence, the 11th of October, in fact, that's wrong, it's 7th of October 2021. The police commissioner has written to the Premier in relation to unfilled vacancies, and I hope the Premier Minister of Finance may be of assistance in that area. Should that not happen and should these problems continue, then I recognise in an extreme situation, section 103 could be used.
Thank you. Thank you.
But it was used by Governor Duncan in 2017. I think it was not without some local controversy.
But one final point, and that's it. I mean, I think you've addressed levels of pay in the public service, and as I understand it, you say, and this is in your sort of 5th of March 2021, the Cabinet accepted a paper from the Deputy Governor's Office to review the pay structure of the public service, which will commence shortly, and that is separate from the pay review in relation to legal.
That's correct. I thought there was a particular, I'm not saying there were not particular problems in other bits of the public service, but because of my responsibility for rule of law and for the courts, I thought that was an absolute priority to be addressed. I heard the representations from the Attorney General and the DPP, and therefore took an initiative. The Premier agreed, and that's moving forward with the Deputy Governor's Office taking forward that accelerated review.
Before I move on, Governor, we've been looking at issues around your responsibility for the public service and overall, but we've obviously moved into the area of responsibility for the police. But is there any other matter in your written response that you now want to draw the Commissioner's attention to?
I would simply say, as I said in paragraph 4.10 of my response to potential criticisms, that UK government funds can be accessed to support elements of the transformation programme going forward, particularly those related to good governance. So I hope very much my office can support further work in those areas beyond what has already been agreed in the MOU, which was signed on 16 September 2021, and beyond the support that's been given, of which I've given evidence since 2018.
Can we take a short break, please?
Certainly, Mr. Kasdan. Certainly, it's due, Mr. Kasdan. How long will you be?
Not very much longer.
Okay.
I think once we resume after the break, that should be done very shortly.
Good. Thank you, Mr. Howard. We'll have another 5-minute break, Governor.
Thank you, Commissioner.
Mr. Rowett, we're ready to proceed. Thank you.
Thank you. Governor, can I move away from governance and just ask you some questions about some discrete matters? Could I ask you please just to pick up what should be the part 2 belongership bundle, which should be on your right, and turn to page 1270.
Yes, thank you.
I've taken you to a memorandum dated the 13th of May 2021 from the Ministry of Natural Resources, Labour and Immigration. And it's headed Applications for Certificate of Residence Status, January, March, April 2021. It is dealing with applications which are done under the standard procedure. We've heard of the fast track programme that was initiated in 2019, but this is one where the Board of Immigration is still in play. We know from evidence that the board makes recommendations; it does not make decisions, and so all of the applications will end up before cabinet. Some the board will have recommended, some the board will not. And if we look at page 1271, please, and it's been redacted, but I'd ask you just to take care not to mention names or any details, including the offence, if you know it. But what's said is an applicant was not recommended. The board recognised that although that person had resided in the territory for over 20 years, the criminal record exists, and then the offences are set out. And then it said, as stipulated in section 18(1)(a), a person receiving certificate of residence should be of good character, and therefore these persons should not hold any criminal record within the territory. And then what's attached is the details, in particular police record of the individual concerned. If you look at 1272, under legal obligations, and this is the input from the Attorney General's chambers, that they say they've reviewed the paper and have discerned no adverse legal implications which would arise if Cabinet is minded to decide in accordance with the decision sought. Now, we don't have the minute of Cabinet, but what we do have is the decision that was made, and we see that at page 1288. It's the same memorandum number. And so it records that Cabinet grants residence to 188 persons. But if you turn through, Governor.
Sorry, Mr. Howard, with respect, I think you do have the minutes of the Cabinet meeting. It was in the papers which I submitted.
I see.
Sorry, it may not be pertinent to what you're going to make, but I just wanted to put that in the record.
That's fair enough. That's helpful. I shall look at that. Let's do it in stages. We do it firstly with these papers, please. It might be that we can deal with it like that. But what you have in terms of this decision, and it starts at 1288. That's the record of the decision itself. Yes. And going to 1298, what Cabinet decided to do was not to accept the recommendation of the Board of Immigration, and that the recommendation being that a certificate of residence should not be granted to this individual because they were not of good character as required by the section of the Immigration and Passport Act. And so Cabinet decided that they should have a certificate of residence. Now, presumably you were the person, you chaired that meeting, did you?
I did, yes.
And what was your position in relation to that meeting and in relation to that particular application?
Thank you. Well, the Cabinet paper which the Attorney General has granted the requisite waiver for submission to the Commission records my position. I obviously accept the need for sensitivity over the redactions in the cabinet paper, but I was appalled by the decision that was reached. The Board of Immigration had made a clear recommendation that a certificate of residence should not be granted in this instance. Without again going into detail, one of the offences was not a minor offence, and I made very clear in Cabinet my view that in light of that offence and the recommendation of the Board of Immigration that the certificate of residency should not be granted, but Cabinet took a different view. So that is an example, to go right back to the beginning of today's session, where the Governor advises and cautions, but where contrary to that advice and caution, Cabinet took a different decision. But I thought it was a very poor decision indeed.
But what was the rationale for you saying that it was a poor decision?
Because it was contrary to the criteria which would normally be applied and contrary to the recommendation made by the Board of Immigration. But I recognise that under the legislation, Cabinet had a discretion in this area, so it was a decision which Cabinet could, within the terms of their discretion, take. But I thought it was a very poor decision indeed.
So if you turn up page 1 on the main bundle, the belongership bundle, page 1441.
Yes, certificates of residence, thank you.
So this is the Immigration and Passport Act, which provides that, subject to the other provisions of this section, the Cabinet may, after consultation with the Board, grant a certificate of residence to any person who applies for the same in the prescribed manner and who is A, is of good character, and B, in his or her application stated an intention to reside permanently in the territory. So the requirement is that the person should be of good character.
Yes.
Was it your understanding that it was because this individual was not a good character that the Board recommended that a certificate of residence not be granted?
Yes.
And did you conclude on the documents that were before you that the person was not of good character?
Yes.
I mean, page 1271, which we've already looked at, which is the Cabinet memo for this. It says, as stipulated in section 18(1)(a), a person receiving certificate of residence should be of good character, and therefore these persons should not hold any criminal record within the territory.
Yeah.
Okay.
And I recognise there may be some very minor offences, let's say very minor traffic offence, which may not necessarily go to the character of the individual, but that was in this instance.
If we look at the documents that you have provided to the Commissioner with your written response, that is at page 47 is where we find the deliberations of Cabinet.
Yes. Page 47 in
the material that you provided to the Commission.
Yes. Okay. Thank you.
Without going into the detail of it, it appears that you raise concerns that the individual concerned had clearly been convicted of an offence and therefore was not of good character. But is it my understanding from the discussion that ensued in Cabinet that the Cabinet proceeded on the basis that they wanted to give this person a second chance?
Thank you. Yes, I think it would be inappropriate for me to discuss individual views expressed by ministers in Cabinet, but that was the overall position of Cabinet.
And the understanding given to you was that Cabinet had the discretion to do that?
The advice given by the Attorney General would seem to indicate that there was scope for Cabinet to take the decision that it did.
Thank you.
Because I suppose ultimately it depends on the definition of good character.
If I move on to a different topic, please. We have taken evidence as to statutory boards and the role they play in the life of the BVI. Now, we've seen when we looked at the Constitution that there are some entities for which you have responsibility in terms of recruiting personnel to those bodies. Could you just remind the Commissioner which bodies you would have some involvement in recruiting individuals to?
I think the statutory boards to which I make appointments include the Recovery and Development Agency Board, because I make some of the appointments to that board. The Parole Board, together with the Premier, I believe the Chairman of the Firearms Advisory Committee. And there are also boards for Old Government House Museum, and I believe the Virgin Islands Cadet Corps Board. So there are a number of boards for which I have responsibility. Most of those are statutory. And I also appoint the Chairman of the Public Service Commission and the Chairman of the Police Service Commission.
And in terms of recruiting for the posts to which you appoint, what is the process that you adopt? Well, for some of them, I'm yet to, myself as Governor, come to in terms of the process I will adopt. But for the, I can tell you, Mr. Rawat, is that for the Chair of the Public Service Commission, the Chair of the Police Service Commission, which I think are two very important positions under the Constitution, those positions are advertised publicly. And similarly, in relation to the positions such as the Commissioner of Police and the DPP and the Auditor General, to the extent I'm working on recommendations from, well, for those bodies, those positions are also advertised. In relation to the Recovery and Development Agency Board, in the most recent recruitment, there was advertising for the Recovery Development Board, but that hasn't always been done on a consistent basis. And I welcome the initiative which the Premier has taken in relation to advertising for statutory boards which fall under his remit, and going forward, I'll be looking at areas where we could perhaps advertise further, where we've not advertised publicly in the past. And does that include advertising more widely for posts, for example, on the Public Service Commission, beyond that of the Chairman?
I think there'd be benefit in doing that, yes. I think there may be some very specialist bodies where open advertising may have its limits, for example, in the Firearms Advisory Committee, where there are very clear criteria for who needs to be appointed. So if you do advertise, you're advertising to a very specialist audience rather than generally. But yes, I think there's much to be said for moving to greater advertisements taking place hitherto. And so I welcome the initiative in that regard.
Thank you. Commissioner, I've reached a point where in terms of the final questions, we may need to deal with them in private.
Yes.
So this may be perhaps a good time for you to hear from Sir Geoffrey.
Yes, Sir Geoffrey, we're coming to the end of the questions. We just have some questions on matters for reasons I've explained earlier today, which we will go into private session for. Sir Geoffrey, what about your application to question the Governor?
Well, I'm usually only up this late, Governor, Commissioner, when I'm watching a horror show. It's 11 o'clock at night here, 6 o'clock your time. And I'm extremely reluctant to lengthen the governor's stay this evening. Even in the Virgin Islands, it's at 6 o'clock. However, I'm afraid, I think, obliged to pursue my application.
Yes.
But I fear that I will have certainly something approaching an hour, possibly a little longer than that, to canvass. Certainly it's been shortened considerably by Mr. Rawat's questions. And I really wonder whether you think it's appropriate for me to embark upon it this evening. I have to say that personally, at this time of night, even at 6, I'd be reluctant to engage, partly because I'm quite convinced that fresh, it could be shorter. And I'm always anxious not to start these things when tired for that very reason. So I would submit to you, sir, that the most appropriate and, if I may say so, fair thing would not to request me to do it this evening, but if possible, to do it on another occasion, which would, of course, give me opportunity to collect and focus in any event. But of course, I'm aware that the governor is an extremely busy man, and it would be a considerable favor if he were to be able to return for a short time.
Which are the areas that you would wish to ask questions of the governor?
I can say those fairly easily. It's chiefly the public service. Yeah. And there are aspects of the minister's concerns, which, although Mr. Rawat did a valiant job, have not been, I think, canvassed to the point where I think some of the questions and answers that I can address to the governor may very well help you. Apart from that, I think there may be one or two other areas that may revolve on the budgetary questions about which the governor gave evidence very helpfully. We haven't seen those figures before, although I think those instructing me wrote to the governor's office requesting that information. I'm not sure if they got the material back. They may well have done, and I've simply missed it. But it will be, I think, generally in the areas of the public service, the budgetary provision and arrangements made. There may be one or two questions, if I have an opportunity to focus my thoughts on the earlier part of the questioning to the governor, which revolves around the appropriate conduct and the constitutional comity between the governor's office and the elected institutions, but that will be relatively short.
But I mean, I'll come to the governor in a moment. But if we were not to start now, but to start fresh at some other point,
yes,
you would focus. You would be an hour, and those are the sorts of issues. That's the sort.
That's exactly it. Yes, and may I say that given a little extra time, it maybe I can focus it even more sharply.
I'll come to the governor now, particularly because the governor is not compellable.
No, of course. That's why I said it was a favour.
And he's not been obliged to answer any questions today, but I'm very grateful that he has. Governor, you've heard from Sir Geoffrey Cox. I think ultimately under Section 13, it's a matter for my discretion, but it may be sensible to canvass your views, but there are some questions that he'd like to put to you on behalf of the elected ministers, and you've heard how long they'll take and the areas to be covered.
Thank you, Commissioner. Well, of course, I will be guided by your ruling on the matter, but I have, if there are questions beyond those which have been asked by Mr. Rawat, I have no objection in principle to trying to ask further questions from Sir Geoffrey, who's acting on behalf of the Attorney General in this matter, but I would wish to avail myself of legal representation in those circumstances. I did not ask for legal representation for the questions put to me by the Commission, but I would wish to avail myself of legal representation if I'm going to be examined. Of course, normally the Attorney General would be my legal advisor, but these questions have been put on behalf of the Attorney General, and so I think I need separate legal representation there. So that might take a little bit of time to organise. But if that can be done, I'm actually hoping to go away for a few days next week, Commissioner, but subject to that, of course, I will be happy to assist as best I can.
And in terms of legal representation, the length of time that it will take, just so that we can organise your coming back to give further evidence, about how long will that take, Governor?
I would hope we could do it not next week, but the week after would be my hope, Commissioner.
So a sort of couple of weeks.
Couple of weeks, yeah. If that would be acceptable to yourself and others involved, because I want to give the best evidence I can.
Okay.
Commissioner, may I suggest a way forward? I mean, firstly, I think you may need a slightly better formulated application to determine, and maybe the first step that can be done is for Sir Geoffrey to set out in a letter, perhaps with a little more detail, the areas that he wishes to cover with the Governor. You can then determine that on paper, and that will resolve that issue. That doesn't preclude the Governor now putting steps into place in order to secure legal representation. We will need to ensure that whoever is appointed receives the bundles, and in that sense, having assistance from Sir Geoffrey as to the areas that he wishes to cover with your permission may also help us. So I'd suggest that as a next step, and then what we will have to do is find a convenient time that suits everyone, where we can conclude this.
Okay, that's helpful, Mr. Wright. Sir Geoffrey, I think Mr. Wright makes a good point about the areas in which you'd like to.
I'm very happy to sketch them out in writing. I would. I mean, I hesitate to say that the Governor has nothing to fear from me. This will be a very temperate and careful exercise. It really is a question of elucidation, nothing more, on matters that in some cases have already been well covered. But I completely understand his desire, and I shall set it out in writing if that would be helpful. My only concern, sir, is that the timing of the return, if it's as long as 2 weeks away, could place me in a difficulty, because I'm due, I regret, to be in a completely different time zone for some time. And I'm a little worried about that. But if it really is necessary, I wonder if next week was too soon. Because it's not going to be a lengthy examination by me.
From Sunday.
Sir Geoffrey, a couple of points.
Yes.
Firstly, although I obviously have fairness to the witnesses at the forefront of my mind,
Right.
I wasn't concerned about fear on the Governor's part about facing questions from you. In terms of better outlining the areas.
Right.
But there are a lot of documents, we have a lot of documents, and it would be very helpful to us all if we could focus on the areas and therefore focus the relevant documents.
Yes, I can certainly do that. I'm just a little anxious about the timing, as I mentioned, because I want, if next week would be possible, I would urge that we could conclude it then.
Next week, as I understand it, is impossible for the Governor because the Governor is...
I didn't hear it.
Going away.
I'm away.
I see.
Away until the 1st, from Sunday away to the 1st, as I will be the Premier.
Right.
If we were to provide us with his availability and a sense of the time difference that may exist, we can try and see if we can. It's slightly moving pieces around the chessboard, but I'm sure we.
Yes,
and avoid a late night horror show, I hope.
Yes. Geoffrey, if you could let us have both the areas
yes.
and dates and times that are convenient for you, we'll certainly take those into account and do what we can to.
I'm most grateful. So I as I say, it may be that I just have to do it from the eastern hemisphere where I'm going, at whatever the time difference.
I mean, I'm afraid, Sir Jeff, you may.
Yes,
And
yes. We'll
may,
manage that.
because I've already mentioned briefly the possibility of, well, I've mentioned briefly, we've briefly discussed closing submissions.
Yes, we have.
And it may be that this additional hour can be at the same time, at the same hearing as any oral submissions in closing.
Yes, yes, indeed, sir. Thank you.
Likely to be in 2 or 3 weeks' time, I guess. So that may all sort of fit together. But if you could let me have those detailed times. Today is Tuesday, but if you could let me have those by, say, the end of Thursday, Sir Geoffrey, that would be very helpful.
Yes, I'm due to be with you tomorrow. I shall try my best to do the end of Thursday, except that I shall also be with you on Thursday. So it might be a little bit difficult for me to do it while I'm, so to speak, paying close attention to the proceedings. Could we leave it like this, so that I will do my best to get it ready for you by Thursday? It may have to pop into Friday if that weren't too long for you.
That would be fine in terms of the areas. If you could have your convenient dates and times, suggest as soon as you can. That will just organise things from a practical point of view. That's all.
Yes. Thank you very much. So thank you.
Good. Now, I think that is all in terms of the open session. We have to deal with radar barges, for which we're going into a private session. And so I'll just pause for a moment while that happens, and then we'll conclude the business of the day in private session. I understand we're back now with on live stream. Can I just say that we've now concluded the matters that we needed to deal with in private session. So Geoffrey, what I suggest is that when the transcript of today is available, then if the attorney can let us have any redactions from the part that's been in private session that she considers are necessary, then hopefully we'll be able to publish some, if not all, of the private session. But that's the way we'll deal with that. Mr. Rowett.
Commissioner, just to say that I have concluded my questions, and can I thank the Governor for coming to give evidence today. We started a little later than he perhaps expected, and we've also possibly finished a little later than he perhaps expected, but we're grateful to him for making himself available. But can I also thank him not just for being here, but for the way in which he has given his evidence.
And can I echo that, Governor, particularly as you're not a compellable witness, and therefore you are here voluntarily. Thank you for your time, which is slightly longer, as Mr. Rowett said, than we had perhaps hoped. Thank you for your time. Thank you for the evidence that you've given, very helpful, and thank you for agreeing to come back to some questions put by Sir Geoffrey within the next couple of weeks or so, and we'll make arrangements for that. Thank you very much.
Thank you, Commissioner. Thank you, Mr. Rowett.
May I also thank the Governor, sir, for agreeing to come back. And I think, if I may say, on behalf of the elected ministers, I think the exercise has been extremely valuable. I address the Governor in saying this. I think it has been most helpful. Thank you.
Thank you, Sir Geoffrey. And tomorrow, Mr. Rowett?
Tomorrow we start with another witness.
At 9 o'clock?
At 9 o'clock.
Okay. Thank you. We'll close now until 9 o'clock tomorrow. Thank you very much.
Thank you.